Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case. Dati mihi Anglican for service Latino.
That's really not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Tammy says, seat in the back dressed in gray. We're matching. We're matching, Tammy. I'm also dressed in sort of gray, black. It's like black and white stripes. It's probably the worst thing to wear on TV, but here we are. Here we are. Good morning. Welcome. Welcome one and all. Oh, I need to run something over here. Hang on. Why are the buttons not working today? We have to have a special person that just takes care of the buttons for us, apparently. What did I do to break the buttons? I didn't change anything. All right, I'll do it manually. Welcome to Greeners. Congratulations, Greeners. First in chat today. We are excited to have you here, and your excitement is evident because you are so excited to be first on chat, in the chat room. We're going to send it to you to internet ownership, which means you are responsible for everything IP related worldwide, at least until we go live again. I do want to give a shout out to any new people who are here today. Thank you very much. It was absolutely awesome, and when I say awesome, I cannot tell you enough. It was an honor to be invited on the Lawyer You Know's podcast. Peter is absolutely incredible. He's the same off stream as he's on stream. It was a lot of fun to go on there. We filmed it last Thursday, and just to be able to hang out with one of the pillars of LawTube. I think he's probably one of the most established as far as time on the internet. Going back 6 years in LawTube. So one of the pillars. Very good. It was awesome. Thank you very much, Peter. Appreciate it. And you, it was a blast. I loved it. All right, let's see. We have. It's a new day. It's a new week. I know we're still in the teens in December, like December 16th, but we're getting really close to Christmas. So I went and tried to send some packages. I'm trying to get a package up to Ian, right? Send a bunch of packages. I was trying to get a package up to Ian, and the Postal Service, the USPS, would not accept it. They said, no, we won't take packages if it's going to Canada. I'm like, clearly you watched Ian's live stream and you thought that when he was talking about and saying, well, when Ian said this,
because we here in Canada hate you and hope for bad things for you because we hate you.
He was not talking about the United States Postal Service. He was talking about UPS, which you share some letters together. He was not talking about you guys. Please rescind your decision, United States Postal Service, because I refuse to send my package to Ian via UPS. Because then he would have to pay, you'd have to give his, a bottle of hot sauce, which is valuable in return for it. We don't want to have that happen. So we'll see if, I think word is that maybe the Postal Service ended its strike or will end its strike tomorrow. So maybe we'll be able to send something then. Welcome, Red Pen. Congratulations. 23 months. One more month to pinkness. Adam, you're green again. Wonderful. Red Pen, congratulations. One of our OGs. Thank you very much. Selena K gifted a membership this morning as well. Thank you for that. We always start the morning off with... there's no better way to start the day than singing happy birthday. I think that should be like a Hallmark saying. But we have a large group here, and pretty much every day for the last I don't know, maybe a year or so. We've been singing happy birthday to people. And so we're going to do that today. And when I say we, it's not me singing. If you're here for the first time, you might think, oh, I could just sit here and listen. That's not how it works. What we do is everyone together, all of us, wherever we are, driving, in an office cubicle, in the boss's office, in a meeting, it doesn't matter where, we stand up and we follow the instructions and we sing together to celebrate these birthdays. We have Amy Flo, Holly Mack, Heather R., and Brenda, heavenly birthday, all celebrating their birthdays today. We sing for everybody. And you're part of that now. So everyone stand up, take a deep breath, shoulders back, get ready to project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. Very good, very good. Here we go. I've got dancers at the ready. We will have an air drum finish at the end too, so get ready for that as well. Happy birthday to you. Happy birthday to you. Happy birthday, Amy Flo, Holly Mack, Heather R., and Brenda. Happy birthday. Happy birthday to you. Amy, Holly Mack, and Heather. First of all, heavenly birthday to Brenda. To Amy, Holly Mack, and Heather, thank you very much for being here. We realize there are a million places you could be, a million people you could be with, but you've chosen to be here and celebrate with us. The privilege and pleasure is all ours. Hopefully we can turn some of that back to you and make your day a little more specialer. I'm going to make that a word. I'm going to make it a word. Help yourself to free pancakes at Denny's, IHOP, Village Inn, Tammy Dunlap's house, Andy's Bar and Grill. No, it's just
Happy
Andy's
birthday.
Grill.
You look good.
Oh, Judge Fleischer weighs in. Says you guys look great. Thank you, Judge Fleischer, for a little cameo appearance there. Canada Post is on strike. Yes. Why? If you go back 10 years, there's probably only one strike, and it's during the time I'm trying to get Ian a package in the mail. Fun. Happy birthday to all those celebrating. I hope I didn't miss anybody. Happy birthday. Consider yourself sung to, and may this birthday be the best one yet. How about that? Tony says, good job on Broken Baker. That was a fun one. I did like hanging out with Broken Baker as well. That was absolutely a blast. He's a lot of fun. We raid each other back and forth a lot. But I don't know who won. But we rarely get to on stream together, so that was neat. Holly Mack, happy birthday to fellow celebrators. Thank you very much for the super chat, Holly Mack. I appreciate that. Holly, if you can now just get the postal service in your country to function. We've got things to do. Oh, the drum you heard, that's our cue. We're going to do a big air drum finish. All of you play the air drums, even if you didn't know it. Grab your air drums, chicks. We're going to hit around the toms,
Happy
then hit the
birthday.
crash.
You look good.
Here we go. Ready? Beautiful. Now you're all singers and drummers.
The zombie apocalypse may be upon us.
And isn't the day just better now? Good thing Greeners has the internet today. He has the experience. Why, yes, he does. Love Broken Baker. You were great. It was a lot of fun to be on his channel. Never been. I've been on other channels, but not in Denmark, like hosted out of Denmark before. That was a first. Never been to Denmark, although I have been to Norway. Twice been to Norway. I've got family over there. Let's see.
I think I'm about to catch a whooping.
Was that Greeners who said that? Peter did a great job. Loved that interview. Every minute of it. It was. I was nervous. Hopefully, it didn't show too much. But Peter's an incredible host, and
in front of the
can't say
Walmart.
enough good about him. Love that. All right. I want to go to Norway. Norway is beautiful. It's a beautiful country. Things are a little different over there, but where I stayed in Norway, it was at my grandparents' house, obviously. Not obviously, but it was obvious to me. That's the only place I would have stayed. They had like cobblestone streets there in Larvik. Like it was like old, just amazing, beautiful. I
saw a chicken fight.
It was a lot of fun. I counted the beads of sweat that streamed down your face. Thank you, Adam. What's the total count?
Have them send someone with more experience.
What's the total count? Where they fed you banana sandwiches? Yes, they did. They fed us tons. I remember going to, and it was my mom's friend. She should have known better, but my mom is Norwegian, and she has friends over there. And so my mom's friend read in the paper that we ate banana sandwiches. And she, instead of just calling my mom, because they used to talk all the time, instead of calling and talking it over, she just made a massive, like a heaping tray of banana sandwiches. I'm not sure where you even get a tray that big.
I think I'm about to catch a whooping.
It was the size of tray that you would maybe, I don't know, present a whole roasted pig, adult pig on, if you were of the type that eat whole roasted adult pigs. But instead it was just like a pyramid of banana sandwiches. All beautifully cut, like in halves, because we were kids.
Shame on you, sir.
Anyway, that's where we were. We're going to do a little bit of court hopping. We have not picked our next case yet. So if you have some suggestions, please let me know, as we're looking at a couple things. There's a lot of stuff coming up next year that we're trying to sort of pencil in the books and decide what we want to do, especially when it comes to travel, if we need to be on site for some of them. I've said I want to be there for Corey Richens. I want to be there for Brian Koberger, but Brian Koberger, I just don't think I can pull off financially, because that is like half a year. His trial's going to be 12 weeks long. It's months. Can we watch the Wet Bandits trial from Home Alone? Is that what you're talking about? Anyway, lots of fun coming up. We're super excited about some of the cases that are happening, and there's obviously the case in Kentucky. Possibly might be able to go there for that one. It's gonna be shorter. I can tell you that, shorter than Brian Koberger's. Why would I have all my normal feeds are gone? I've got Surviving a Blizzard. I bought an abandoned super yacht. Pepsi Mega Factory. 36 hours on an Amtrak train. Everybody, all my normal feeds are gone. Who's been watching on my channel, on my feed? Okay, we'll figure it out.
Have them send someone with more experience.
Did you leave the Airbnb logged in as you? No, Greeners. I'm so careful about that.
When are we going to break for lunch, Judge?
Mindy's ready for lunch already. I'm actually so careful in our Airbnb that after a guest leaves, I go in and make sure they don't get left in. I perform a reset on the TV and then completely reconnect, brand new. I even forget the networks and then come back. So if you're a repeat guest in my Airbnb, it's not just going to work like it did before. You'll have to set it up every time. Which reminds me, I need to start telling them the Wi-Fi password. What is your favorite Christmas movie? Mine is National Lampoon's Christmas Vacation. I thought I answered this. I don't really have a favorite. Mostly because my memory is terrible. I'll have to think of it. I'm sure there's some good ones. Rosie for Justice, in here from Lawyer You Know, also happy to subscribe. Thank you, Rosie. Wonderful to have you here. Peter was absolutely amazing, as you know. It's not just fantastic hair that he has. He's also got the legal know-how and incredible delivery, and he does YouTube right, which is something we can all aspire to do. Let's see.
I was kicked back, taking it easy.
All right, only answers questions once. Adam, it's good to have you back in green. So we get this wit all day long, apparently. Let's see, the Grinch, the new Grinch, and Elf. Elf was a good one. But I don't know how A Christmas Story. That's what I said before. I'm going to go back with that one. Mostly because I wanted a BB gun the first time I saw it too. And I finally, as an adult, have that BB gun. That's why I'm choosing that one. I would show it to you, but YouTube has rules, and that would probably violate them. I've already probably broken the rules because I mentioned that I have one. All right. I was watching a couple judges this morning that we might want to jump in on. Just one second. Judge Simpson's not live yet. We want to catch him in the morning. I always like him early in the week. It's a little depressing to watch the landlord-tenant cases, although we've seen some good ones. It's always sad to see people that are basically at a low point in their lives and are having to basically move when it's not convenient for them, or come up with a lot of money that they just don't have at that time. And it's, it makes you sad. It makes you sad. Oh, okay. Questions. Let's answer a couple questions. First of all, thank you, Sharon, for this reminder. We have an award show that we're doing, the Addict Awards, and we'll do it over the Christmas break. And by that, I mean it's going to be sometime between Christmas and New Year's, right at that period, maybe even very close to New Year's. And during that show, we would like you to make nominations for who you think should win awards. And by who, we're talking about people in trials, judges, attorneys, defendants, prosecutors, maybe even witnesses who deserve an award. There is an award form you can go fill out here. Please fill out the whole thing. It helps us complete the award, and it makes it more likely that we choose your award if you do. So the more nominations we get, the longer the show lasts. If we only get 2 nominations, it will be a short. I'm telling you, it will be a short. I'm not going to just nominate everything and vote myself, because that's not the way democracies work. Did I witness any drones in the sky? No, in Through the Outdoor, I didn't. But, I sat up last night saying, if I were to do one of these live streams, a drone watch, how would I do it better? And I need y'all to find me something that doesn't exist, or find a machinist who can make me one of these. I need a Picatinny rail that mounts to a camera tripod. So you've got the tripod, and then you have the rail that screws right in like the base of a camera does. And then you can clamp scopes to that. Because I would do a multi-mount. So you have like side-by-side cameras. You've got a color camera. You have a scope from ATN that has either night vision or thermal on it. And then I'd mount my phone as well, because I would do an overlay, the AR overlay that would allow me to put the images and descriptions of all the planes floating over the picture. I'm telling you, this is how you need to do it, right? You need your AR, augmented reality, plane identification, because you can point to anywhere and it will show you where the plane is. So if you see a light on one screen, it will say, oh, that's Delta 7 whatever flying to JFK. So that's what I'm doing. So anyway, a Picatinny rail with a captive 1/4-inch 20-thread thumb screw. Yeah, 6-volt. That's all I ask. I saw one once on eBay, and I can't find it again. You lost me at Piccadilly. Piccadilly Circus, that's a London place. Different. Been there. Beautiful. Love it. Lots of fun. Picatinny rail. Think of like a scope that goes on top of a rifle. This would be the part that the scope clamps onto and holds onto, and so mounts onto the gun. So it's like that, but for a tripod. Just wait until you see a Starlink trail go by. It's weird. Oh, I've only seen one. Although I have Starlink and it works beautifully. All right. My son got a BB gun when he was young. He used it until it stopped working. I had a 10-pump Crossman. I think it was a 760 BB gun before I got a Red Ryder even. And we used it for BB gun wars. Like all the neighbor kids had BB guns. We had a rule, because 10 pumps is a strong shot. You could only pump it once or twice if you needed to, because anything over that would break the skin. We all wore shop glasses for safety, though. Amazon has them. Text me a link to the burner phone if you've got. I need the receiver to be able to be threaded by any tripod. Not like one of these Arca tripods or anything else. Selena K got her screaming goat. That is wonderful. Waiting for court right now. We're stalling for just a minute. Karen, late coming in. The show with Lawyer was awesome. I'm still a holdout on her guilt. You both made some great points. Happy Monday. Karen, thank you very much. My wife watched. I have a hard time watching myself. I really do. It's easy when I'm right here. I only have to see myself in a little tiny picture, or maybe sometimes like that. Yeah, I have a hard time watching myself, so I don't go back and watch the shows when I'm done. I just pretend it never happened. Expecting mine today. You see that, Jennifer? Jennifer's expecting. Congratulations, Jennifer. No, just kidding. Your goat is arriving. It's not going to spread. It's not spreading rumors, Jennifer. It's all right. I have to say thank you to a couple people before the judge starts. Weebug sent me a matched pair of. I haven't opened them or mounted them yet. A matched pair of emotional support pickles, his and hers. So I think we've got a Mrs. R.A. and me, R.A. Emotional support pickles. Thank you. I will say I have a small herd of emotional support pickles now. And Sloth Life sent me a decorative item right here called a skin-do. A skin-do. This is a pokey stabby, which goes in the sock of your Scottish outfit. And it has the pokey stabby bit on the inside. But this is just for show. It's not an actual weapon of any kind, and any possible reflectiveness is because it's plastic, and and definitely not going to slice my finger off if I tried. Thank you for that one. Sloth Life. It's very nice. It's very nice. I appreciate that. Pokey stabby is my new favorite euphemism. Selena K, my dogs are terrified of the screaming goat. Hey, it might work for, a dog training device. It's useful for apples. Yes. Pronounced skin-do. Skian-do. I can't get Mr. Chambers, Richard, I can't get the pronunciations right, even if I tried. Do I eat bananas now? I do. I do actually like bananas. I'll eat bananas in cereal. Like, I'm a big fan of, Cheerios with sliced bananas in it. I'm not sure if that's a thing. I'm pretty sure I saw it, on the cover of a Cheerio box when I was a kid, and that's just how I eat them. But obviously with milk. Bananas, Cheerios, and milk. Yes, Screeners. Milk. All right. Judge Cedric Simpson is taking his sweet time, so we might have to see who else is on this morning. It's a little early for Stephanie Boyd. Let's see. No, we haven't done any parole hearings in a long time, and I'm feeling the urge to find a parole hearing. Louisiana Parole Board. Michelle's Mixed Media Madness votes for a car chase. Banana and peanut butter. Oh, see, I'm not alone. Atlanta Troy does it too. Is Judge Boyd's on already? Get to the right screen here. Judge Stephanie Boyd. Oh, she's up early. Let's pop in and see what's happened. I was going to say, what's that blue water jug? But that's a TV.
Thank you.
Oh, are they back in trial? I think this is still the trial, right? We watched part of this.
Thank you so much. I'll call you when we are. All right. Thank you.
There she is. Yeah, this is closing arguments. We have not followed this case. We popped in a little bit, and it was tough to find the part we wanted. But it was a little spicy. That attorney in gray that's got his chin in his hands was a little bit...
I should have asked them.
A little fiery.
State Defense, are you all going to need this cart?
Judge, I plan on using it.
All right.
We might stay here just to see if it gets fiery. We need for you to not do another accident reconstruction. I'll have to get my son's toy cars again. Haven't had a good car chase in a while. Here's the problem. California is, I think, trying to become less known for their car chases.
I'm ready, Your Honor. So I glanced at the Joe Barrett case, and I understand the concept.
But here,
Oh, you can remain seated.
thanks, Judge. Here, it is a little bit different. We had a pretrial hearing. We had not a pretrial hearing, but we had a pre-testimony hearing where the state had this information. They have an on-duty. They do have an ongoing duty to disclose. And while I understand what Joubert is saying, that in their case in chief, but they still can't lie. It doesn't give the state the ability or the right to lie in wait with this information.
Well, so you do agree that, one, it was done as rebuttal. Do you agree to that defense?
Yes, Your Honor.
All right. And you do agree that it was admissible as rebuttal?
I don't know that it was, Judge. I don't, because it was never tied to Mr. Morrison. They never went through the predicate of tying it to Mr. Morrison. Had they tried to admit the protective order, that would have been one way to do it, but they have not tied. All they did was ask questions about an affidavit that was never tied to Mr. Morrison. So I don't know that it is admissible under those scopes. They have to make it somehow. I can't just make up an affidavit and read it to the witness and ask if they know about it. There needs to be more than that. I was making objections throughout their cross, so they didn't.
Objections were not to foundation.
It was
Not to foundation. Am I correct in that?
That's correct. Yes, Your Honor.
All right. State.
Judge, pursuant to Jalbert v. State and Gullett v. State, it's the state's position that they were not entitled to evidence or notice of that evidence because it was used in rebuttal in response to his testimony for his defendant's character proof.
So new evidence brought in rebuttal that hadn't been disclosed to defense. They forgot to make foundational objections.
All right. So to solve the issue, the court could give, I don't know if in the charge, if there's any instruction on extraneous.
There is, Your Honor. Yes.
Well, would there be a different instruction you request, Mr. Locke, other than the extraneous instruction that's currently in the charge?
Yes, Your Honor. I'd ask that the jury be instructed to disregard any.
That's not going to happen.
They didn't really hear any evidence tying the protective order to Mr. Morrison, and so I would ask that they be instructed to disregard the.
That's foundation.
You have heard allegations that there was a protective order. That protective order was never, tied to Mr. Morrison. Therefore, that line of questioning should be disregarded. I think would be the appropriate instruction.
That's a big ask. It's not going to get that.
State.
Judge, during the questioning, it was regarding whether the witness was aware that the applicant applied for a protective order. I don't think I ever made the representation that one was granted. And so we don't believe that, it was in rebuttal, so we don't believe that he was entitled to notice regarding that. It's a response to his own testimony regarding his client's peacefulness.
All right.
Josh, thank you very much. Just let me know. Well, she was off the record for a second. Just let me know that the trial we were expecting to have start with Judge Simpson this morning was the state announced they could not proceed. They were not ready, and so it didn't happen. It didn't happen. So no Judge Cedric Simpson trial this morning. I was hoping we'd get that. It's rare to get a trial in his courtroom. This judge, if you're not familiar with Judge Stephanie Boyd, she's out of San Antonio, Texas. She doesn't put up with crap from anybody, but she's also got a huge heart, and I think she's one of those judges that in every situation wants to do what's best for the defendant. And sometimes what's best for the defendant is to lock them up and get them treatment. And sometimes what's best for the defendant is to grant them bail and let them give them another shot. She's remarkable at that, but she wants people to take ownership of their actions. And she wants people to, be better and do better. She has an amazing collection of handbags. Most of them are gifts from her mom. She brings a different one every day, and it sits behind her on the bench, as you can see that on her desk. And she also has gets regularly gifted flowers. We ourselves have sent a display of flowers to Judge Boyd's courtroom, and it was delivered on stream. We got to see it as it was delivered. It was really cool. But she gets flowers from a lot of different people, and she buys them for herself as well. So always probably the best looking judge's bench in all of Law Land. She wants you to dress appropriately for court. Don't say my bad in front of her. She'll say, oh, my mistake. Yes. Don't say my bad. She wants you to stand in the right place. If you're a prosecutor or defense attorney, just follow the rules. Don't talk by the recorder's table. Be respectful in her court. Show up on time. Just the bare minimum. I mean, really, it's not like she's asking, people to deliver the moon. She just wants people to be respectful and take ownership for their actions. Did I call children kids? Yeah, I think growing up I would be told that a kid was a baby goat. No kids, those are baby goats. There you go. There it is. She saw a video of roaches fighting once. She did. We have a sound effect from her court. Actually, I think we have a couple. But one of them was when she was talking to a defendant saying, look, you don't want to go to jail. Okay, jail's a bad place. And not just a bad place. It's a dirty, creepy, crawly place. She said that.
Somebody just sent me a video of roaches fighting. I don't know who won.
Yeah, she said somebody sent me a video from our jail of roaches fighting in the jail.
The zombie apocalypse may be upon us.
Tingling with Gina.
All right, we can go back on the record.
Mabel should preside over the Susan Simpson case. That's in Bexar County. Possibility.
One, the court notes that there's already an extraneous language in the charge. The court will add to the charge that attorney's questions are not evidence. That's what the court proposes to add to the jury charge. Any objection to that being added to the charge? State?
Yes, you made a choice, not a
Defense,
mistake.
any objection to that being added to the charge?
I don't object to the additional language, but my objection to the jury's ability to consider that evidence remains.
All right.
Overruled.
All right, that'll be denied.
And I would also ask for a mistrial, Your Honor.
All right, that'll be denied.
His heart
All right,
wasn't
I'll
even
have
in
that
it.
added to
He was
the
looking
charge.
down while he said mistrial. And I'll also
To
ask
the
for
extraneous evidence?
Well, the extraneous is already added. What I'm going to have added to the charge, since both parties said they had no objection, was to remind the jurors that attorney's questions are not evidence.
You can't see me. I'm so
Will
sorry.
you add that to the extraneous evidence charge?
Where do you want it placed?
I would like it in the extraneous evidence charge.
What specifically do you mean of you want it in the extraneous charge?
But where we have the extraneous evidence,
I'm excited. This week I get my new desk as well.
Page 10?
yes.
All right.
You'd either add it to the beginning or to the end.
Okay. All right, that can be done.
Thank you, Your Honor.
I don't think she likes him. The way she says okay is the tale. It's very telling. I don't think she likes this attorney. Let's see if they get started here in just a minute. I just want to, I know it's late, but catching the closing statements might be interesting because I think they're going to be a little fiery. Can I have a mistrial and the moon on the stick, please? Bob, that's pretty much it. That's pretty much it. I don't even know the charges on this. Tammy, a new desk is at Christmas? No. The thing is, this desk is, I love it. My family got me this desk and surprised me with it. It's awesome. It's really cool. I love that it's carbon fiber look finish. The new desk is just going to be black, so it's not going to have this little sheen to it like we see here, these lines. But the new desk is black and it's got room. It's bigger. It's probably, I think, an extra almost 2 feet wider. It's L-shaped. It's a standing desk. Broken Baker was using a standing desk when you were on with him? I couldn't tell, Holly Mac. I couldn't tell. I thought it was seated. That's really cool. Yeah, we're gonna stay here on this one because I think it's gonna be spicy. I think we're gonna have some good court moments and possibly even some epic one-liners from Judge Stephanie Boyd. Libby, carbon fiber sounds great as long as you're not building a submarine with it. Comes in with the Titanic reference, or the Titan, I guess it was. The desk has lights, like it has colored lights built into the desk that light up some of my equipment, and it has a shelf so I can put my monitors on top, and a lot of these items that I have on my desk will go underneath, and so I'm gonna have a lot of room. Let's see. Does anyone know that in this particular case, the judge has been handling this case probably for 3 days now, I think. What were the charges? We jumped in a little bit when he got spicy, but I haven't been able to follow this all the way through. Might get to see Judge Boyd come January. I'm really curious about what I might be in. Silly Claus, are you talking about just visiting the courtroom or possible jury service in her court? Sinbad, it's been like pulling teeth trying to find this case. So I'm looking forward to the closing statements here where we get to hear it all laid out for us. Salty Girl, thank you very much. It was such a privilege to be on with Peter. It was really, really cool. That was a major highlight. Oh, the federal grand jury. Right. Okay. That makes sense. Would she be presiding over that? Would there be another judge that handles that? A little disappointed that the Judge Cedric Simpson's bench trial didn't go through today. That would have been neat. Selena, depending what the case is about, obviously, if this is a case with a whole bunch of child victims, we might not stick around for the whole thing. But the attorney in gray, the one who just fought quite aggressively to have some language added to the jury instructions, he's the reason I'm here. He's why I want to watch this one. I have reached out to Dr. G. We're just trying to find a date that works for the both of us. And let's see. Let me ask him if this Friday works. See, what's the date on Friday? The 20th? Dr. G is Dr. G Explains on YouTube. He is a clinical psychologist. So he's an expert witness, and he also does, some body language analysis. And really, he's just a nice guy. We bumped into him, and he's just incredibly gracious. His YouTube channel is exploding. I mean, it's doing phenomenally well. Love what he does, and he'll just pop in there, and we get a close up. This is the guy we're looking for. What's he wearing? Is he wearing a microphone or a camera? What in the world? What was that on his jacket? Did you guys see that? It was a microphone. I think they turned it off because they've got a little sidebar going on right now. And they don't want to be able to read lips. Better this way than the white noise. Check your burner. Laura, I'm not sure which one it is. Whichever one's in trial right now is the one we're interested in. But I don't know. I don't think they're doing all the charges at the same time if there are multiple ones. We'll wait out here for a minute while they get sorted out in her court. I think she's getting the jury instructions ready. James Craig's status. Which one's James Craig? Give me just 1 second here. That's the dentist, right? Solicitation to commit murder and solicitation to commit perjury. Ooh, that'll be fun. Colorado dentist. He's expected to appear with new counsel on the 16th of December. That's today at 8:30 a.m. Just a little background on the James Craig story. If we can find this, we might pop in and look at that one. His wife, Angela Craig, died on March 18th, 2023 from lethal doses of cyanide and tetrahydrozoline, a decongestant found in over-the-counter eye drops. She suffered through several bouts of sickness where doctors could not determine the cause. Ooh, that looks like poisoning. James Craig was arrested early the following day on a charge of first-degree murder after deliberation and is accused of poisoning her protein shakes. Wow. According to the affidavit, James Craig made multiple orders for arsenic and cyanide. They also found messages including travel plans with a woman that was intimate in nature and contained sexually explicit conversations. Oh, so it has spice. Wow. He is the Colorado dentist.
Computer systems are down. So that is the lateness. It's not due to any of the attorneys or persons not being where they were supposed to be. So what I'm going to do now is I'm going to read you the charge of the court. You don't have to memorize it. You will have the original back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant Christopher Morrison stands charged in counts 1 and 2 of the indictment with the offenses of aggravated assault with a deadly weapon alleged to have been committed on or about the 3rd day of June 2022 in Bexar County, Texas.
2022.
To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally or knowingly threatens another with imminent bodily injury. 2, a person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 3, our law provides that a person commits the offense of deadly conduct if he recklessly engages in a conduct that places another in imminent danger of serious bodily injury. 4, bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. 5, a person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct when he is aware of the nature of his conduct. A person acts knowingly or with knowledge with respect to the circumstances surrounding his conduct when he is aware that the circumstances exist. You are instructed that a person acts recklessly or is reckless with respect to the circumstances surrounding his conduct or the result of his conduct when he is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 6, count 1. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did use or exhibit a deadly weapon, namely a BB gun, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Christopher Morrison did intentionally or knowingly threaten imminent bodily injury to Jesse Izaguirre by shooting at or in the direction of Jesse Izaguirre with said deadly weapon, then you will find the defendant, Christopher Morrison, guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and do not consider any lesser included offenses under count 1 as instructed in paragraphs 7 and 8, but skip to paragraph 9 to consider count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and proceed to paragraph 7 to next consider whether the defendant is guilty or not guilty of the lesser included offense of deadly conduct under count 1. 7, lesser included offense of deadly conduct under count 1. Now, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did recklessly engage in conduct that placed another, namely Jesse Izaguirre, in imminent danger of serious bodily injury by discharging a BB gun at or in the direction of Jesse Izaguirre, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of deadly conduct under count 1, and do not consider paragraph 8, but skip to paragraph 9 to consider count 2.
Welcome, Allie.
If you do not
Good to
so
have you here.
find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of deadly conduct under count 1, and next consider paragraph 8 to decide whether the defendant is guilty or not guilty of the lesser included offense of assault under count 1. 8, lesser included offense of assault under count 1. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did intentionally or knowingly threaten imminent bodily injury to Jesse Izaguirre by shooting in the direction of Jesse Izaguirre with a BB gun, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of assault under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of assault under count 1. 9, count 2. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did use or exhibit a deadly weapon, namely a BB gun, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Christopher Morrison did intentionally or knowingly threaten imminent bodily injury to Michael Izaguirre by shooting at or in the direction of Michael Izaguirre with said deadly weapon, then you will find the defendant, Christopher Morrison, guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and do not consider any lesser included offenses under count 2 as instructed in paragraphs 10 and 11. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and next consider paragraph 10 to decide whether the defendant is guilty or not guilty of the lesser included offense of deadly conduct under count 2. 10. Lesser included offense of deadly conduct under count 2. Now, if you find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did recklessly engage in conduct that placed another, namely Michael Izaguirre, in imminent danger of serious bodily injury by discharging a BB gun at or in the direction of Michael Izaguirre, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of deadly conduct under count 2, and do not consider the lesser included offense of assault as instructed in paragraph 11.
She has me right
If you do
up
not
till
so
BB gun.
find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of deadly conduct under count 2, and next consider whether the defendant is guilty or not guilty of the lesser included offense of assault under count 2 as instructed in paragraph 11. 11. Lesser included offense of assault under count 2. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of June 2022 in Bexar County, Texas, the defendant, Christopher Morrison, did intentionally or knowingly threaten imminent bodily injury to Michael Izaguirre by shooting in the direction of Michael Izaguirre with a BB gun, then you will find the defendant, Christopher Morrison, guilty of the lesser included offense of assault under count 2. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Christopher Morrison, not guilty of the lesser included offense of assault under count 2. You are instructed that questions by the attorneys are not evidence, and you are not to consider any question posed by the attorneys in direct or cross-examination of witnesses as evidence. In this regard, if there is any evidence before you regarding the defendant having committed offenses or acts of misconduct other than the alleged offense against him in the indictment in this case, you cannot consider said evidence for any purpose. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict.
MySpace is out, guys. Quit using MySpace.
Off the record for a moment. You need to remove your hat.
Oh.
Back on the record. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict as to each count independently, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict on each count, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment.
Or just violence.
A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict.
She's almost done with
All
instructions
persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdicts are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be on each count, and you may or may not, as you see fit, make use of them. At any rate, your verdict on each count must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by your presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
So the state that brought us the Alamo and the Texas Rangers is now prosecuting this gentleman for shooting someone with a BB gun. Not necessarily the high crimes that we normally hear about, but charged with assault with a deadly weapon, a BB gun. My sister shot me with a BB gun. Should I press charges?
This is a deadly weapon. A deadly weapon is one that is capable of causing death or serious bodily injury. A deadly weapon is not a weapon that is capable of causing death or serious bodily injury in every conceivable scenario or every possible circumstance. It's just a weapon that is capable of causing death or serious bodily injury. Pendleton testified that after testing this weapon, he concluded that this is capable of causing death or serious bodily injury. But even if you discount Pendleton's testimony and his conclusion, this weapon did this to this sliding glass door. The weapon that did this could do similar
I'm guessing
to a
it broke
human
the
being.
glass.
That's a deadly weapon. Now, Christopher Morrison fired this weapon at or near two people. There was testimony that Mr. Morrison is well trained and experienced in the use of weapons, both firearms and possibly of this type. If Mr. Morrison is so well trained and experienced, what can we conclude from him firing this weapon at or near two people? The answer is that he either intended to cause them imminent bodily injury, or he knew or should have known that firing at or near them could have or would have caused them imminent bodily injury. That's a threat that Mr. Morrison either intended to make or knew or should have known that he was making. That's assault. Assault committed with this deadly weapon is aggravated assault with a deadly weapon. That's what Mr. Morrison is guilty of committing. Thank you.
The worst thing that can happen with a BB gun, obviously you can shoot your eye out, but
Defense.
You can
May
get
it please the court.
beaten to death with the gun easier than you can get
Good morning.
killed by being shot.
I told you at the beginning of this case, there was an honor and privilege to represent Christopher Morrison. It really is. It really is a privilege. It really is an honor. An honor, frankly, that I might not be worthy of. He served this nation. And now I get to advocate for him as we use the rights that he fought so hard for. I also told you this was an American tragedy. An American tragedy. How we ask so much of our veterans, and we're so quick to throw them away. That's what this case is also about. You can't deny that. Very sad. It's 2.5 years. You've heard evidence. Morrison has used that time. Come back from the dark place that he was and build a life, a really good life, in Indiana. Actions of June 3rd, 2022, not something he's proud of. Very sad about it. Very sorry. Didn't commit these offenses. Didn't commit the offenses that the state is alleging. He just didn't. He didn't. And state, frankly, when it comes up here, it really doesn't describe the testimony accurately. Why is that? Why don't they describe the testimony accurately? You heard their expert witness. Let's see the date of that report that he filed. It's more than a year old. And they could have asked the questions that I asked. Questions that establish that Chris is not guilty of this offense. The big offense that they allege, the aggravated assault with a deadly weapon. He's just not guilty of that. Okay. In the laboratory, that BB could go 315 feet per second. How fast could it go that day? I don't know.
315.
Was it a deadly weapon the way Chris used it that day? I don't know.
That can bruise you.
If he doesn't know.
It can hurt your eye.
If he doesn't know that in its use and intended use, it was a deadly weapon, how can you? You haven't heard anything else. So he testified. Their expert witness that they called testified that he didn't know. That is a reasonable doubt. It is a reasonable doubt that came directly from their testimony. Absolutely. in our instructions, it says that the presumption of innocence alone is sufficient to acquit him. And that's what we have. We have a presumption of innocence and their witnesses saying that they don't know. What else didn't they know? I asked Izzy, Officer Izagire, I asked him, did you ever find out what landed in the pool? No, I don't know. I don't know. That's what he said. You have these BBs. Remember, he describes, you can open these up and you can feel one of these BBs, how light they are. He describes a splash that goes over his head. That wasn't a BB. It just wasn't. So that's a reasonable doubt. Were those splashes, could they have possibly been caused by these BBs? We don't know. The state didn't prove that. So Mr. Morrison is not guilty of everything. You should go through the verdict forms, go to that second line, and sign the not guilty verdict on each allegation that the state has made. But let's go through step by step. Let's go through step by step. And so the state does bring up the sliding glass door. How did that happen? What did the state prove to you? Did they arrest Mr. Morrison for that? They did not. Go to your exhibit or your instructions, page number 10. Go to page number 10, and it says anything that he's not accused of, you shouldn't consider it. They are also asking about a protective order from his girlfriend. They asked her about that. She had no idea about that. Why would they do that? They never tied it to him. Not once, not with any piece of evidence or information. No date of birth, no case number, no nothing. You can't consider it because he's not accused of it. So you have to take the sliding glass door out of your deliberations. You got to take the protective order out of your deliberations because they're just irrelevant. That's what the instructions say. So then we look at the different allegations. And it starts on page 6, paragraph 6, I'm sorry. And there's the big one, the aggravated assault with a deadly weapon. So for an aggravated assault with a deadly weapon, you have to really believe, that he was trying to kill the people in that pool with a BB gun. Now remember, they're expert. Is this a deadly weapon? I don't know. In the manner of its use, intended use that day, is it a deadly weapon? I don't know. That's a reasonable doubt. Have to find him not guilty of that. Because he did not intentionally, there's no evidence that he was intentionally trying to kill or seriously injure or maim the people in that pool. Gail and Izzy. So we go to the next thing. And the next one is the deadly conduct. Okay? So here we have recklessly, and recklessly is like you disregard a substantial risk. That's reckless. And I do think, right, okay, that shooting the BB gun in this apartment complex is probably a reckless act. Not an intentional act, not a knowing act, because he's not trying to hurt or kill those people, okay? But reckless, okay. So maybe they can clear the bar on reckless, but again, they have a problem. Because it has to be in danger of serious bodily injury. Can this cause serious bodily injury? This BB gun, it has to hit your eye at a very specific speed. Was it going that speed that day? I don't know. Where else could it hit? If you hold it 3 to 5 feet away from your chest, it could cause serious bodily injury. Well, we know that that wasn't the case. That's not what happened that day. Other than that, you know if it was, I don't know. So could it have caused serious bodily injury using the BB gun? The answers are, I don't know. That's a reasonable doubt. That's a reasonable doubt. And you have to acquit Mr. Morrison. So then
I have a lot to say about BB guns here when we get a pause.
Intentionally or knowingly. So that means that he's trying to scare the people in the pool. Okay, and there's a part of Jesse Izaguirre's testimony where he said that he was looking around in the balconies and he sees somebody and they make eye contact, and he identified Mr. Morrison, and they make eye contact, and Mr. Morrison's surprised. Like, he's surprised to see somebody in the pool. He's describing a surprised reaction. There's no evidence that Mr. Morrison knew that there were people in that pool, that he saw them, or that he was trying to target them. He wasn't threatening them. He didn't want to hurt anybody. And that is the consistent evidence throughout the case. So we have this testimony. We have these officers. How did we get here? How did we get here? There were some very important discrepancies in the state's case. Very important discrepancies. First, we had Detective Rodriguez come up. And she couldn't tell the same story twice to save her life. She constantly changed. How many times did you talk to Jesse Izagide? Once. I talked to him once. Except when I called him on the cell phone. Okay. And we had a detailed conversation, and that's where I found out. And then I talked to him by the pool after I turned my body cam off. There were 3 conversations. Why is that important? Because she's giving all this detail. She's giving all of this detail, right? But none of it's captured on her body cam. Why did she turn her body cam off? And then see everything that was important that happened after that and describe it. Why didn't she turn her body cam back on? Oh, she did when she was going to approach the apartment, but not until then. Be very skeptical of her testimony. Detective Izagide or Sergeant Izagide. Do you know Detective Rodriguez? In passing. We know in passing. We're members of the same department. Everybody kind of knows each other. Detective Rodriguez. No, Sergeant Izagide? Yes. I have a nickname for him. His name's Izzy. We were part of the same class. We're part of the same class. That's incredible. Those are important discrepancies. You cannot then take what they say at face value. You have to be skeptical because they've been shown to be honest many times. So then you got Pendleton. He comes in. He very clearly says that on the day of the offense, he does not know that this thing would have to be very close to the chest, cause death or serious bodily injury, or actually hit an eye at a very specific speed that he couldn't establish that it was going at that on that day. That's reasonable doubt. And we had our witnesses testify. We had our witnesses testify. And you found out about Chris Morrison's service. You found out about his service. Found out that he's been going out on hundreds of missions. He is an expert marksman. That Shiloh Harris, who goes on these missions with him, who went day after day, was willing to put his life in his hands based on his ability to shoot. More evidence that Chris did not intend to threaten or hurt or scare anybody. You heard his girlfriend come in. She testified that he's a gentle guy. In the state, they ask about some protective order. She had no idea about that. She hadn't heard anything about that, and it didn't sound like anything to do with Chris. Did they ever tie that to him, and why didn't they? And then, instruction number 10. Instruction number 10 says, if he hasn't been accused directly of this, can't consider it. That's the sliding glass door, and that's the protective order. Those 2 things.
I think he's made room for reasonable doubt for his client. I wouldn't acquit
years.
just because he was a veteran.
We've been protecting Chris.
I don't think that's an adequate defense.
So he could get his life together, so he could get himself established and in a good spot. He's there. He's used that time to do what he needs to do, make sure that he's not in that dark place that he was at on June 3rd of 2020. He's used that time well. We're now handing him over to you. Handing him over to you. This morning, last night, I always toss and turn jury trial. And I think to myself, well, what happens if I
2
don't make the
minutes.
right argument? Thank you. What happens if I don't make the right argument? What if I say the wrong thing? Last night, as I was thinking, I did think about 12 of you. You come together, strangers, come together in our free country, protect somebody who has fought for our freedom. Thank you so much for letting me do this, Bruce. Thank you. It has been an honor and a privilege. It really has. I can only hope, as I did go to sleep last night, I was comforted by the thought that you all will follow your oaths and find him not guilty. Thank you very much for your service. Thank you.
All right, N's trying to be likable, both the start and the finish.
State.
State might take a little longer on this rebuttal.
Yes.
Let's see if we can see this video, even from the side. Body cam, maybe?
For some reason, I thought, what's the big deal? It's a BB gun. Ladies and gentlemen, the big deal is that this BB gun, State's Exhibit number 12, is a deadly weapon. And you all heard testimony from David Pendleton saying so. Their own witness, Mr. Harris, said that State's Exhibit number 12 could cause serious bodily injury. That is what makes it a deadly weapon. What also makes this a big deal is that it was fired at Jesse Azagita and his 3-year-old son. Now I want to talk to you about the mental states. We talked about this in jury selection.
PowerPoint
You're
finish.
not required
Not
to
strong.
read the mind of the defendant. You can infer this from his actions and the circumstances surrounding. Now let's talk about recklessly. It's a conscious disregard of a substantial and unjustifiable risk. At a minimum, the defendant acted recklessly. His own defense counsel just conceded that to you. Now, let's think about this. The defendant has expert knowledge regarding firearms due to his military experience. He has expert knowledge of gun safety, and so he knows that there's a big risk if someone is hit by that BB. Now let's talk about knowingly. Aware of the nature of his conduct. Did he know what he was doing when he did it? I submit to you, yes. And how do we know this? He was aware that he was shooting the air rifle into the pool and into the window of apartment 303. He's aware that he lives in an apartment complex, that there's multiple people that live in that apartment complex, and that the pool is a public area where multiple residents frequent. Yet he's shooting upon it. And he was aware that Jesse and Mikey were in that pool. Now, what makes intentional in this case? What other reason would he be firing into a pool of 2 individuals? Because it was his desire, his marksman desire. This goes back to what we talked about in the Titanic. When Cal is firing upon Jack and Rose. What was his intent?
I missed
now
that.
we talked about
I
in
didn't
jury
watch that
selection, testimony is evident. So let's talk about the witnesses that you all heard from. You heard from David Pendleton, who's been with the crime lab for a number of years. He testified that State's Exhibit number 12 is capable of causing serious bodily injury. And how does he know that? Because the velocity necessary to cause serious bodily injury is 246 to 249 FPS.
That's the bare minimum.
Velocity of State's Exhibit number 12
for your eye
was between 315 and 337 SPS. That is way higher than what is necessary. State's Exhibit number 12 is capable of causing serious bodily injury. We have heard testimony from 2 witnesses that concede to this. And that is what makes it a deadly weapon. Now, defense wants you to believe that the velocity was inaccurate, that it was lowered by the weather, that the velocity was lowered by the distance. Let's look at the evidence. This is the pool from the defendant's apartment. This was the pool from the defendant's apartment, and you can clearly see people. Okay, so this notion that he wasn't aware that someone was in the pool is a fallacy. This is the view of apartment 303 from the defendant's apartment. And this is the velocity of State's Exhibit number 12 illustrated. 315 to 337 SPX.
I'm gonna object to the this is extraneous evidence that the jury should not be considering. It's improper closing.
All right, ladies and gentlemen, you remember the evidence as it's been presented to you. You may proceed.
Ooh,
now let's talk about the testimony that you heard from
evidence.
Jesse Ezagita. Jesse Ezagita testified that he overheard harsh splashing 3 to 4 times within arm's length of him. And this put him on alert.
Harsh splashing.
When he heard the window shatter, it was at that point he believed that somebody was firing a gun or a pellet gun. And at this point, he decides to take Mikey out of the pool. Once he heard the racking of a firearm, he was sure of what was going on. So sure that he decided to put his 3-year-old behind a pillar for cover.
I need to see the BB
He
gun here.
observed the defendant laying in the prone position on the balcony of apartment 251, which is the same apartment that officers made contact with this defendant. Jesse Ezagita testified that his fear was on level 10. And this is something that defense attacked because he's a police officer and he serves our community every single day. Why would he be on a level 10? Because he has his 3-year-old with him. He was in such fear that he reached for his duty belt, and he testified to this on the stand. He reached for his duty belt because he was going to retrieve his weapon and fire in return. That's how scared he was.
Whoa. That's
he was in fear that he was going to sustain
crazy.
imminent bodily injury. And he has no reason to lie. Everyone testified that the defendant and Mr. Ezagita had no prior interactions with each other. So what would he gain by making this story up? Absolutely nothing. And the evidence is consistent with his statement regarding hearing the window shatter and the racking of the gun that was found in that defendant's apartment and apartment 303 that is right across the way. Now let's talk about Detective Rodriguez. Ultimately, her conclusion was that she believed that the defendant fired upon Jesse and Michael Ezagita. And there's the evidence that was to suggest that was Detective Ezagita or Sergeant Ezagita's testimony, right? His statement, the cracked window, the BB gun, and the defendant's own admission that he was firing the BB gun. Now, Detective Rodriguez did testify that the defendant made an admission of shooting into the pool to Officer Ashby. But according to defense, that's not a good admission because they want you to believe that when a defendant tells someone what they're arrested of, that's not an admission. It is. It is. And why else would he say it if it isn't true? Now let's talk about the defense witnesses that you heard from. Mr. Shiloh. Even he testified, State's Exhibit number 12 can cause serious bodily injury. He also testified to firearm safety rules that we all know, which is you treat every weapon as if it's loaded. You don't aim unless you're ready to shoot. You never put your finger on the trigger unless you're ready to pull it. And then he made some mention about flagging. You know, I'm not a trained expert in firearms, but when I took it out of the bag, the barrel crossed him. And it made him so uncomfortable that he had to, bring it to everyone's attention that I did it.
She pointed the gun at
imagine
the
how,
witness.
Jesse and Michael felt when they were being fired upon. That is something much more serious than a firearm that's been made safe in a courtroom, me, displaying it to him. And regarding Ms. King's testimony, she testified back in 2022. She wasn't really that close with the defendant. And I submit to you all that she doesn't really know him as good as she thinks she does. Now, during your deliberations, you are solely deciding guilt, innocence. That is what the defendant is charged with in the indictment and what you will receive in the jury charge. On or about June 3rd, 2022, that is not in dispute. You've heard testimony from multiple witnesses saying that that's the date the offense occurred. In Bexar County, Texas, that's not in dispute. The defendant, that's not in dispute. Did use and exhibit a deadly weapon. That's not really in dispute. You've heard testimony from multiple witnesses that that is a deadly weapon because it can cause serious bodily injury. Did intentionally or knowingly, I've already made my arguments regarding that, and threaten imminent bodily injury. You all are going to be able to take those BBs back there, those metal BBs, and you can decide for yourself. What are not defenses to this indictment is whether a 911 call was purged, whether the detective had continued contact with the victim on the day that she made the location to take his statement, whether the detective has a working relationship with the victim, or whether there were no BBs located in the pool. Ladies and gentlemen, use your common sense. Pools have filters. They have multiple filters, and the police didn't go out to conduct their investigation until the next day.
2 minutes.
There was no chance of them finding those BBs. That does not mean that the offense did not
things
occur.
really well.
We cannot hold these things against Jesse Izagita, and we surely cannot hold them against Michael Izagita. Now, you're instructed to not let bias or sympathy play into your verdict. And so we talked about this in jury selection. If you believe he needs help, or you feel sorry for him, or he was having some type of mental health or substance abuse issue at the time, those are things that you consider in punishment. You do not consider them in your deliberations right now. You all swore that you would render a verdict true according to the law and the evidence. What makes an aggravated assault with a deadly weapon? The defendant threatening Michael and Jesse with imminent bodily injury and using or exhibiting a deadly weapon during that threat. While this defendant is guilty of the lesser included offenses, the more appropriate charge is what is charged in the indictment, and that is aggravated assault with a deadly weapon.
Aggravated. Wow.
Ladies and gentlemen, there's an opportunity for justice to be had today.
Welcome, Broken Baker
you.
And Baker crew.
You all decide when he gets that BB gun back and when he can fire it again. And so I ask you to find him guilty of the offense of aggravated assault with a deadly weapon.
Time. Right on the button.
All right, ladies and gentlemen.
We're going to give them, I think they're going back to deliberate right now. Let me tell you a couple things about BB guns really quickly. First of all, yes, it is possible. I don't like the idea that they're grouped in the same category as, say, like a 50 cal sniper rifle. Okay, the deadly weapon. They are, first of all, a BB gun is not fired with an explosive charge, so they're not technically a firearm. There's no gunpowder burnt under under pressure to fire the projectile. It's usually pneumatic or spring power that fires a BB. There are a couple different things that people think about when they say BB guns, and they're different classes. And somebody brought this up. You have a BB gun, which sounds like what was used here. A BB fires a .177 usually, little metal ball, little copper ball, or copper colored ball or steel colored ball. Very lightweight. It's a very small projectile. It loses its speed rapidly. A BB gun that has about a 350 feet per second muzzle velocity it will be able to throw that projectile almost 200 feet. Like 175 feet is about as far as it's going to go. The closer you are to the gun on that 175 feet, the more damage that can be done. Obviously, point blank, they can be quite damaging. I don't know what the range we're talking about here. The next one is an airsoft gun. An airsoft gun shoots a little larger diameter pellet, and they're usually a plastic, think of like a plastic bead or a plastic ball. They can also be gel filled as well. But these plastic balls, they usually, and these airsoft is designed to be used to shoot at other people in simulation games. You can search up airsoft battles, and people go out and they wear like a mask and they go and they shoot each other with these. They shoot up to 500 feet per second. And yeah, they can leave a pretty good mark. Okay, they can leave a pretty good welt and even break skin. But with the right face protection, you're not going to have a serious bodily damage done by that. The last one is a pellet rifle. Pellet rifles are a little tiny lead. Typically, it's a lead pellet that is shaped so it fills the diameter of the barrel, so which is also .177 or .22, or there's some bigger ones as well. I think you can get even up to .357 caliber air rifles. But the pellets usually fly a lot faster. I have 2 pellet rifles and 1 BB gun rifle. My 2 pellet rifles, one shoots at about 750 feet per second. The other shoots at 1,250 feet per second, which is right up there next to the sound barrier, the speed of sound. Much, much more powerful than a BB gun. Not all BB guns are the same. You can get BB guns that will shoot over 1,000 feet per second. This one seems to be on the low end, where it's 350 feet per second at muzzle. Still can hurt somebody's eye, but what it will not do is throw a splash when you shoot the water that will go higher than a standing man. That doesn't happen. Physics doesn't work that way. So I do have problems with a little bit of the testimony that way, but it's not okay to shoot at people with a BB gun if they don't want to be shot at. I was standing, growing up, my house, directly behind my house, first of all, we had a big retaining wall that was like 25 feet tall because there was a catch basin, retention pond in case there was a flood that came down out of the canyon, this basin would catch the flood. So it was behind my house. I was up on the top of the wall, the dirt road at the top, above the retaining wall, which was probably 200 feet away when my sister shot me in the back with my BB gun. And man, I felt it. She pumped 10 times, 10 pumps. That BB gun shoots about 1,000 feet per second. That was through clothing, and it hit me in the back. It hurt pretty good. Could have definitely done number on my eye had it been at my eye. And she should have just called me, because 200 feet, I can hear you yell. I would have come home for dinner. You don't have to shoot me first. Anyway. Interesting little story here. Waiting for Judge Boyd to come back. We'll listen in when she does. Paintball hurts too. Paintball usually, let's see, on the low end, like people who play paintball for fun, like just casually, I think it's like 200, 250 feet per second is what they'll shoot those paintballs at, and those are bigger caliber. They're like about the size of a marble. Those will hurt too. They've got a little weight behind them. I think the professionals shoot a little bit faster than that, but I'm not a professional. I've only shot the lower ones. BB guns are usually used for target shooting. Yeah, a BB gun you can buy, like if you go to the store like Walmart, they used to sell BB gun target traps that were designed for indoor use. So you would literally, I'm not sure if they still sell them, but it was just a metal trap where it has a little metal frame with the back is slanted down. And so the BB would go through the paper target on the front, and it would bounce down and sort of stay in the trap. Paintball hurts. Airsoft guns are really painful. Yes. My son just sold his airsoft sniper rifle. Let's see. Bruise lasted for weeks. Yeah, typically when you're playing paintball, you can have a courtesy kill. Where it's like, bang, bang, you're dead. I would have got you, but I don't want to leave a bruise on you for weeks. Josh sent something to Mod Chat. We might have something to watch while we wait for Judge Boyd's verdict. I think this will be a quick one.
All right, everyone, the rules are still the same. If you want to approach the court, just have them pull your file.
Okay, so what Judge Boyd does while the jury is deliberating is she handles other things on the docket. So now, while we're waiting, you can see the defendant's still sitting there at the defense table.
All right, Mary Guerrero.
She's going to call the next case, so we'll listen in a little bit as she handles a couple cases.
Attorney? All right, Ms. Guerrero, if you'll come forward.
This is the purse judge, yes. She's back.
Hello. Good morning. Good morning. All right, counsel, was an offer tendered?
Offer was tendered. It's not acceptable. We need to see more discovery. So I'm going to get a USB here, come back and give it to the prosecutor.
All right, Ms. Ferguson. On Guerrero, I need 1 month reset for plea deadline dates. January 14th. All right, January 14th. Okay, thank you. Once you sign the reset form, you are excused. And thank you for dressing appropriately for court.
Yes, ma'am.
Thank you. Samantha Venegas. All right. All right, Deputy, could you make an announcement for Samantha Desiree Venegas? Thank you.
Uh-oh, bench warrant. She's not here.
And counsel, I do believe that the bondsman may have filed an affidavit to surrender surety. I'm unable to check because the system is down.
Anyone know why the system's down? The computer system's down in San Antonio? Did they
We're going to go on the record. Court is calling 2024 CR 008052 and 2024 CR 008054 State versus Samantha Desiree Venegas. Could I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
Denny Callahan, not ready, not present.
All right, so this hearing was actually scheduled for an agreed bench trial today. Deputy? She hasn't made it back.
Not ready, not present. What was that?
The court is aware that I believe an affidavit to surrender surety was filed. Is that correct?
I don't know, Your Honor.
Okay. The court is unable to check due to the system Odyssey being down. Deputy, did you make the announcement?
Somebody answered outside, Judge.
All right, thank you.
You're welcome.
All right, State, what are you requesting?
Grant the affidavit of surety is surrender issue, the apprehension of the defendant.
All right. And again, the court believes an affidavit to surrender surety has been submitted, but our systems are down throughout the courthouse, so I'm unable to check.
And Your Honor, I apologize for interrupting. If there is an affidavit of surety to surrender, then grant it.
Okay. So what I'm going to do is I'm going to issue a judge's warrant and remand her without bond.
Yes, ma'am.
All right. Is there anything else, counsel?
No, Your Honor.
All right. You're excused.
Thank you, Your Honor.
Could be an internet issue. Well, the judge is live streaming from there, so I think that would be the same internet connection. How is that different from bench warrant?
All right, anyone else ready? What's your case? All right, did you ask them to pull it?
I did.
All right, have you all pulled Ashley Medina?
It's fun to watch how the different courts operate. Some, like Judge Cedric Simpson, you
all right,
just get on the
Ashley
list,
Nicole Medina.
when he calls your case, that happens.
All right, was she on the docket today? All right, so where is she?
They didn't bring her over, Judge.
Let me find out what's going on.
She's in custody, not
because she just
transported.
came back Friday.
Okay. We're going to find out. That way we'll know.
Is the judge going to make a call?
Richard Casanova.
Who's the prosecutor on Ashley Nicole Medina? It's Criminal Trial Division. On this one, where are we on the blood discovery?
I think it came in the, looking through their file. It came in, right?
I need to check.
It looked like it was in the file, Judge.
Okay. All right, let's see.
Why didn't they bring her over for court?
Let me get your file.
Do you need the cause number? Okay. Yeah, I think the system is still.
It came in, Judge. I just didn't look at it that carefully, but
All right, so you have it?
I have it, yes. I mean, it's in their file.
Oh, you have the blood discovery.
I saw it in their file. But I don't have it with me, but it's in their file. Yes, looked like they had it.
All right, let me.
But has it been turned over to you? Iris, we're going to have to, we're all going to have to sample those. So if you could just let us all have a little bite, that would be
All
great.
right, well, let's make sure it's there.
Funky Cold Medina.
Good morning. Good morning. Odyssey's down.
What's that?
Odyssey's down.
It is? I don't use that.
Yeah.
Judge, I wanted to, I know Venegas that I just found out did not show back up.
This is off the record conversation. She kills the mic for.
Because if I tell them the release, then do you want me to stay? Okay.
Because she didn't show, so I issued a warrant. And I think since it's 10:30, she would have been.
Yeah, it's okay. Thanks, Judge.
My understanding, I haven't been able to go online. My understanding is that the bondsman did an affidavit to surrender surety. So
That's what Mr. Guy said.
It's
Okay.
an upgrade
So
outage.
I'll run back, let release them, I'll come right back.
all right, thank you.
It's the new software, the new improved software that isn't working. Jay Holiday, we used to ask if we could find what that purse was. Usually someone can find it and link to it, tell us the approximate retail value of the purse. A lot of times they are quite spendy, several $100s to over $1,000.
Yes.
So I've had a chance to look at the physical found. It looks like we do have only toxicology reports, but not the data, the support staff, which will be blood discovery.
And how long do you think that will take?
Judge, I would request that before you
Abby, I'm probably not going to stream on
Do you know
Christmas,
what happened with Ashley Medina?
but Boxing Day
All right.
is a maybe.
All right, Norm, I need a 45-day reset on Medina for blood discovery. This will be the last setting for blood discovery. If it's not here, then whoever needs to subpoena will need to come because this has been going on since October. All right, we'll come back on January 30th. Is that a good date for you, counsel?
I hope so, Judge.
2025.
Who's wearing the white suit back there? Does it just looks white? Or is he really in a like full-on white suit?
Yes. Anything else?
No, Judge.
All right, thank you.
Thank you.
Purse looks like a Dooney. Less than 1,000.
Who's here on Mariano Rendon?
This guy's in blue jeans, belt buckle. Is that the defendant?
Oh
yeah. That's the
Are you going to be arguing this?
Yes, Judge.
I'll let you view that and just let me know when you're ready.
Corey says, I just called my water company and they said they couldn't help me because the system is down. And I'm in Texas. Texas, get it together.
Make sure you speak on yours.
Yes, ma'am.
Very urgent.
Brandy's going to do a Christmas Eve stream.
All right, we're going to go on the record.
Sounds awesome.
And 2024 CR 2338B and 2024 CR 2339B, State versus Mariano Rendon. Can I have parties announced for the record for the state?
Megan Galloway for the state of Texas.
Larry Bloomquist for the defense.
All right, we're here. The court received a request for a travel permit from pretrial services. The defendant is requesting to go to Vegas from December 30th, 2024 and returning on January 2nd, 2020.
Vegas for New Year's? He wants to go to Vegas for New Year's?
State, do you have objections?
Judge, so just we would request specific conditions with that. So a UA before departure and upon arrival, as well as prohibited possession of firearm.
All right, when you say UA upon arrival, you mean return?
Yes, yes, arrival and so return to San Antonio.
No drinking in
All right,
Vegas.
do you have any objections to that?
No, Your Honor. And I will just let the court know he did travel one time before for business. We did a UA when he came back and he was clean. I have no doubt that he will remain so.
All right. All right, then the court will grant the request. There's to be a UA completed before you leave and a UA upon return. Do you understand?
Yes, Your Honor.
All right, is there anything else?
No, Your Honor.
All right, thank you.
Thank you, Judge.
You're welcome.
It's a running joke on the channel. We take spam calls from people that try to send us on vacation trips to Las Vegas, and I tell them I have a warrant in Vegas.
I don't know
that
if you got
can't
that,
go
but
there.
I believe that belongs in your file.
We do have a lot of new friends here
Thank
today
you.
from the lawyer. Thank you very much for joining me. I've said thank you many times. Peter is an amazing podcast host. It was an honor to be able to be on his podcast with him that aired this morning. I was terribly nervous. I hope it didn't show. It was a lot of fun. Every time we get a prank call and I say I can't go to Vegas, I make up a new reason why I have a warrant for my arrest.
Enrique Soriano?
I don't. As a matter of fact, I used to actually work in Las Vegas selling metal building components.
All right, so have you received the blood discovery?
I got the, this is what we've received today, video, dash cam, and then in terms of the laboratory diskettes,
it's dressed really well.
we don't have that yet. I went by the window this morning. It's not there, but they are
All right,
providing.
so where's the blood discovery?
Record that is.
Is this the dash man?
No, this is the blood discovery.
Okay, so the dash cam is the one that we were working for. I thought that's what this was.
No, the last time you all were here in August, my understanding that both parties
August.
agreed that there were no dash cams available. That's what the court has in its notes.
Is that
So there's-
correct?
As far as I'm aware, yes.
So state, were you able to tender an offer? All right, Norma, on this case, set it for a plea deadline date in 30 days, please.
So he hasn't looked at the CD. He thought it was dash cam, and there was previous notes saying there was no dash
All right,
cam.
January 14th is going to be your plea deadline date.
Uh-oh.
You need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, your case will be set for jury trial.
All right.
So if
good.
you get the reset form from the coordinator, and once he signs the reset form, he's excused.
Yes, ma'am.
All right, thank you for dressing appropriately for court. You always do, though.
My pleasure, Your Honor.
Thank you.
The
All right,
fact
if
that
you'll
the
just
judge
have a seat and they'll
recognizes
bring
you
the
from other
reset form
times
to
in
you.
court
Thank you.
might be a
Kelly
problem.
Klottner.
Steal your heart, Susan. Welcome to the gallery. Thank you very much. Appreciate it. Atlanta Troy. I think it
On
used
this
to be,
case,
used to be Tumwater Troy.
Blood discovery in?
No.
Thanks for gifting a membership. Vicky
have it.
Mack. Good to have you here. 13 months on Friday the 13th. That was last week.
All right. So, yes, I have in my notes that blood discovery was received on November 18th.
I also think it's lucky. I
And
think
the
I got
state was to
married.
tender an offer today.
Pretty sure I got married on a Friday the 13th.
Wait a minute. The diskettes have been given to me?
If I'm informed correctly, yes.
I don't have it in my file.
All right, he doesn't have it in his file. If you have a copy, if you could give him another copy.
And
And
I've been
then-
looking for the diskettes at the window. I mean,
All right, they have it, so you'll have it, but
Copy
I have it
this.
as being tendered on November 18th.
okay, now there's an additional issue regarding
Judge mutes because she knows what this issue is. Kels Bell's gifted a membership. Thank you very much. That one went to Marissa. And Josh Hutchins gifted 5 memberships. Welcoming a lot of our new friends here this morning. Thank you very much for your generosity.
Correctly, I believe ADA Crespo is working on getting those from Universal City.
All right, can you call him and see what the update is on that?
Kels Bells does it again.
And call her, I don't know if she's gonna pick up.
All righty, we shall see.
Judge, the motion that we filed was more encompassing than that. We want to know not only the status of his cases, but if there's any cooperation agreements that he's having with,
Well, I can't answer your question until they tender what they have to you, or if they think it shouldn't be tendered until I do an in-camera inspection. So I don't have it.
well, okay, then just, I didn't want to limit it just to, okay, very good.
All right, so this is what I'm going to do. I'm resetting this for January 14th. The disciplinary records need to be here in my possession, or either the person who has access to that needs to be here explaining why they don't have it. All right, Norma, if you recall this for January 14th, please.
We are in verdict watch for this trial that we just sort of popped in on the end. I'm not even sure I can remember the name of the.
And then I guess
Christopher Morrison.
Diskettes for Blah.
Jury's
I'll have to
deliberating
check
right
on
now.
that because we don't have it.
The judge is
Your
just
Honor,
handling
I
some
think
business
those
in the meantime.
Might be these,
What, the blood discovery?
this little folder that says Kelly Cotner Blood Discovery.
Okay. All right, there you go.
Okay, then I'll pick it up from them now.
All right, thank you. All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Yes, ma'am. Thank you.
All right, you're welcome. John Roberson,
Oh, wow. You guys are flying
who's
here.
the attorney on John Roberson?
Megan,
Judge.
congratulations on 19 months. Katia gifted a membership. Thank you, Katia. Appreciate your generosity. Iris also gifted a membership.
You got it.
It's raining memberships.
All
Yes,
right, my
Christopher
understanding
Morrison,
that she was going to
the
file a
Christmas Story
motion
BB
with
gun
regards to
trial.
jurisdiction.
I did.
Okay.
You don't have it?
No, I haven't. I just was stating what we're here for.
Yes.
All right, State, did you receive the defendant's motion to set aside the indictment based upon jurisdiction?
I did, Your Honor.
And have you had a chance to review it?
I have, Your Honor.
That
Are
is
you
a
in
tall
agreement?
defendant.
No, Your Honor.
All right. Court is calling. Are you ready to proceed on your
Ready?
Court is calling 2024 CR 006935, State versus John Roberson. Could I have parties announced for the record for the state
Andrew Harris Edelman.
defense?
George Sharman on behalf of the defendant.
And are you Mr. Roberson?
Yes, ma'am.
All right. The defense has filed a motion to set aside the indictment. State, are you prepared to proceed?
Yes, Your Honor.
All right. Defense, it's your motion.
We might have
Judge,
Dr. G this
basically,
week. Maybe.
the
Fingers
line
crossed.
is that
Trying to schedule it.
one of the enhancements that the state is using is a misdemeanor from Travis County. And the defendant, after he served his probation on it, was granted a pardon in 2004 as to that. And as a consequence,
The governor?
it's not a case, a judgment for purposes of enhancement of punishment because of the pardon. And the case that states that is Cuellar versus Spade.
Well, have you submitted any evidence to show that he was pardoned?
There are attached exhibits to the motion. And these were the exhibits that were given to me by the state. And if you look at Exhibit 2, the language in Exhibit 2 says that the case was dismissed. And under 4212 Section 20 back in that period of time, The judge allowed him to withdraw his plea of
But
guilty.
let me ask you this, because I'm reading the order discharging defendant from community supervision. Is that the exhibit you're speaking of?
The one marked that, yes, exhibit.
All right. So what it says in exhibit number 2 at the end, it says that he's released from all penalties and disabilities resulting from the crime of offense, except that proof of said conviction shall be known to the court should the defendant again be convicted of any criminal offense.
He has not yet been committed. He has not been convicted. Not only that, the case is dismissed. It's ordered dismissed. And under the Cuellar case, if you read this, and I've tendered you a copy.
Oh, did you tender a copy to the?
Yeah, I also gave them notice of that under this section of the Code of Criminal Procedure, whenever a judge goes through this pardon situation, that it can't be used for enhancement. So, and this is a copy of the Cuellar case that talks about it.
All right, State.
Defense counsel would have a good argument if he was right, but he's not. Because of the language of 42.12 section 20.
Did you hear that?
In subsection B, it states this section does not apply to a defendant convicted of an offense under sections 49.04 through 08 Penal Code. Those are the DWI provisions of the Penal Code. So now we have a philosophical problem. If a judge issues an order that the judge lacked the authority to make, has the judge in fact issued an order? And the answer, as far as I can tell, is no. In Ray State ex rel Hilbig, several defendants and real parties in interest were convicted of DWI felonies and were sentenced to regular probation. After completing their probation, Judge Hilbig terminated their sentence, set aside the judgments, and dismissed the indictments. The state argued that the judge had no authority to terminate the probationary periods under Article 42.1, Section 20 at the time. And the Court of Appeals of San Antonio agreed because the language of the statute means what it says. 49.04 offenses are excluded from the judicial clemency provision. Additionally, in Bradley v. State, which is admittedly not a published report, the Dallas Court of Appeals in 2002 came to the same conclusion on roughly the same facts as this. When a judge issues an order that the judge had no authority to make, we treat it as a nullity. We ignore it, which means judicial clemency was not granted for purposes of this motion to quash, and it should be denied.
Judge, he's referring to the 2015 version of the statute. And it wasn't in effect at that time, back in 2004, when he was granted the pardon. So what counsel is saying that we can ex post facto apply the 2015 law to my client.
Good arguments back and forth.
Untrue.
Your Honor, may I briefly respond?
Yes.
I am making reference to Article 42.12 that was in effect June 13th of 2001, which contains this judicial clemency exclusionary language. I'd also like to point out that judicial clemency is distinguishable from pardon, which Mr.
Sounds like a DUI.
Robeson has not received.
All right. So first question, was it a pardon or was it clemency?
It was a pardon. It was dismissed.
Respectfully, Your Honor, if I'm informed correctly, a pardon is something that is issued by the governor. And this order was not issued by the governor. It was issued by the judge of the court to which he was assigned for that case.
It's called a judicial pardon.
That's not a pardon. That's judicial clemency.
And the Cuellar case resolved it. That's from the Court of Criminal Appeals. Okay, it's out of Bexar County. And they said that in that case, it cannot be used. And this is current with my client's case and the statute as it existed at that time.
All right. State, have you had a chance to review the Cuellar case?
No, Your Honor. However, briefly looking at it, it seems that that covers a felon to possess firearm offense, which has nothing to do with the judicial clemency language in 42.12, section 20, subsection B.
All right, so the state's argument is that your client's offense, past offense, is excluded from not being used in this indictment. He's saying that under Chapter 42, that DWI is one of those offenses that are excluded as far as whether or not it can be used for enhancement to provide jurisdiction to the felony court. And you're arguing that's not true?
I'm saying it's not true in this case because the judge allowed him to withdraw his plea and dismiss the case. And it works as an acquittal under Cuellar.
Dismissal. How do you hold?
Why does it say, and state, I understand your argument, but then why does the document say that it can be provided as proof if he's convicted of any criminal offense to the court? If someone is pardoned, then it doesn't come back as proof that you're convicted of an offense.
It doesn't say that it's proof. It's in her order. It just says that the judge could be informed of the existence of the prior judgment. It doesn't say it's proof.
No, it says, and what I'm reading, it says it is therefore ordered. And then towards the end, it says, he is released from all penalties and disabilities resulting from the crime of the offense, except that proof of said conviction. That's what it says.
Except proof of conviction.
Of said conviction shall be known to the court should the defendant again be convicted of any criminal offense. Now, I understand what the state is saying with regards to Chapter 42, but defense, you haven't addressed the issue. The defense is saying that, the state is saying that Chapter 42 has been in effect since 2001.
Yes.
The part of the statute, the part of the code that he's reading from. Your
Lauren,
client's
thank you. I would love that.
Conviction of this offense was
Illustrate Life, I'd be happy to tell you. Let me wait till we get a little pause here.
This
And I'll tell
looks
you
like
the story behind the
January
name.
7th, 2022. So wouldn't Chapter 42 encompass this, since this conviction occurred after? And
2002.
yes, and
Here's
the
the
order
short answer.
discharging him from community supervision was signed by a judge in 2004. And the conviction date, it looks like it's 2002. State is saying that code section 42 is from 2001.
That's when I believe that's when it went into effect.
So then if you agree that Chapter 42 is from 2001 and that a state is saying that DWIs are not covered by the exhibits that you submitted to me, then the state would be correct.
Well, it says the language that it uses is that the case was dismissed and that the judge allowed him to withdraw his plea. So it is no longer a final conviction. So in this instance,
this is intriguing.
The language of the judge caused it not to be a final judgment.
He should have gone with that argument
first. I think under those circumstances, under the Cuellar case, that means that it can't be used for enhancement of punishment in this case. It's not expungible according to the statute, but it can't be used for enhancement. And that's what Cuellar says.
All right. State, are you prepared to address Cuellar? Or do you need more time?
Still, Your Honor. far as I can tell, Cuellar is completely off the mark for this. That was a felon in possession firearm case in which the defendant's prior felony conviction was subject to 42.12 section 28 clemency. And the state argued that essentially 42.021A, 42 points, sorry, Your Honor, I'm getting confused. 42.12 section 28 clemency should just be ignored so that the state could charge Cuellar with felon in possession firearm. And the Court of Criminal Appeals ruled that no, the state can't just ignore judicial clemency. That has nothing to do with the circumstances of this case in which a person purportedly received judicial clemency that the court by section 20's own terms, he never should have been able to receive because the court had no authority to issue it. And in this circumstance, what this court should do is to ignore that purported judicial clemency order for precisely that reason.
Roro, thank you very
All
much
right,
for
any
gifting
other
5
argument?
memberships.
That's all we have.
All right, just give me, if you'll step back, just give me 5 minutes.
Okay, the judge has a decision
And I'll
here.
review the documents that you've given to the court.
Precedence is very important for a judge, and especially appellate rulings are very important because it
Gabriel
might indicate
Diaz.
what's going to happen in the future going forward. The argument that the defense lawyer made saying that the case was dismissed was probably his strongest argument, but he didn't lead with that. He started with he got granted clemency, and it said in there you can't hold this against him.
Counsel, have you received all discovery?
I don't know, but today I did, Your Honor. It's my first time, Your Honor.
All right. State, were you able to tender an offer?
Not yet, Your Honor.
All right, Ms. Ferguson, if you recall this in 30 days, state you're to tender an offer at that time. All right, y'all coming back on January 14th, just have a seat and the coordinator will get you a reset.
Thank you, Your Honor.
All right.
Take a seat. Okay, please.
I'm not sure where the accent's from. I didn't recognize that one. She might call the other judge. If this happened in Bexar County and the judge is still serving, it happened back in what, 2004?
That's Gabriel
So
Diaz, and
it's
it's going to
20
be
years
January
ago.
14th. If you'll let
I
Ms.
don't know.
Ferguson know when she comes back.
It'd be a lengthy career as a judge.
Brandon Trader.
What an unfortunate.
Who's the
bad
attorney for
last name.
Brandon Trader?
I'm here now.
Hi. And where's he?
He failed to appear today, Your Honor.
All
FTA.
right. Let me see if he has a PR bond.
I can hear my family listening to Christmas music in the background. Hopefully you guys cannot hear it because that would be bad for the channel. But I was hearing some Trans-Siberian Orchestra just a minute ago. Love that.
Deputy, could you make an announcement in the hallway for Brandon J. Trader?
Yeah, he's not going to be out there. If the lawyer's saying it's FTA, he's not going to be in the hallway.
I saw a chicken.
I saw a chicken fighting. In this court with Judge Boyd, just showing up and being respectful gets you
Can you
a
tell me,
lot of mileage.
Brandon Trader, was he given a PR bond
That's
or
going to
a
be
commercial
revoked.
bond?
Fell asleep during Trans-Siberian concert. Oh, Mel. Please tell me it was a medical condition. They're loud.
And hi, Deputy, could you make an announcement in the hallway for Brandon Trader? Trader? Trader, gotcha. And thank you.
Yeah, later. I appreciate you.
Can see him on the 27th.
Your client may, it's a possibility your client may be in custody. Because I'm reading some of the details.
I asked the deputy. They said that he was not in custody.
Okay.
It'd be better for him if he was in custody in this case, because being in jail and missing court.
All right,
is a
court
valid
is calling
excuse.
2024 CR 010750 State versus Brandon Trader. Could I have parties announced for the record for the state?
Andrew Harris, Adelman.
Defense?
Winnie McClellan.
All right, this hearing was scheduled at 9 a.m. It is 10:58 a.m. The defendant has not made an appearance. Defense, have you had any contact with your client?
I have not recently, Your Honor.
All right, state.
Assuming that Mr. Trader is not in the state's custody, bond forfeiture and issue a bench warrant for his apprehension.
All right, the court will issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, you're welcome.
May I be excused?
Yes.
Thank you.
The right thing to do is make an appearance. You do not want to get picked up and dragged in, because then it looks like you were running and hiding. It would be better to say you forgot about court and just
Ayana Hubbard.
hang your hat in shame.
All right, is she out here?
She is here. Oh, no, she was here.
Oh.
Ada K, thanks for being here. I'm sorry to hear your sister passed. Our condolences there. Ada K has a YouTube channel.
We're set.
where she does,
I know the court
sign
wanted an
language translation.
announcement. We're set for in Judge Carruthers' court tomorrow for agreed incompetency.
All right. All right, so then what I'll do is I'm going to recall you back.
14th.
Because
31st.
based upon the nature of the offense, you'll probably be going to the state hospital. So I'll set you for February 18th.
Okay, thank you, Judge.
Long delay.
Yeah.
Oh. Yeah.
All right, on Hubbard, it's February 18th. Clinton Dixon.
That's right.
That's in custody, I think.
Hello.
Oh, nope.
Hi, all right. So where are we on these new cases and intake?
Must be.
Oh, just 1 second. I'll give you a chance, I promise.
This might be interesting.
The aggravated robbery is indicted, Your Honor.
Okay.
The shredded overalls, not my preferred
Possession
court
case
attire.
is not indicted. I don't have any more information about its status than that. Before making a plea offer to defense counsel, I would like to attempt to confer with the complainant on the ag rob.
All right. And just one moment. What is the cause number on the aggravated robbery, please?
I don't remember.
2024 CR 0129476, Your Honor.
It's a case from this year.
If that doesn't pull it up, I have the PF number if you want that.
All right. Let me just do this. You said 2024 CR 0129476.
Yes, Your Honor.
All right. Let me do this.
Sometimes Odyssey doesn't pull it up by that number.
Mm-hmm. All right. Who is the attorney assigned to that? Are you assigned to that as well?
Yes, sir.
All right. And do you have access to the discovery?
Yes, Your Honor.
All right. And there's something you wanted to say?
I thought it was a regular robbery.
Oh, you'll have to talk to your attorney about that.
I wasn't mad during it.
Trying to just go ahead and do a plea deal.
All right. So here's the thing. You'll need to speak to your attorney about that. I'm not your attorney, so I can't step in and say, I'm going to work this out for you. Your attorney will have to speak to the state. What I'm going to do is I'm going to recall you back. And I'll recall you back for January 9th.
I was at least trying to be out for my birthday.
Oh, I'm sorry. We'll have you back on January 9th.
The judge is like,
You'll be with the VA about the police, so I can get out of here, please.
I'll be in touch with it.
All right. Thank you. Alexander Rodriguez.
interesting look. Is he going back in custody? He went out the side door. Okay, if he's in custody, his choice of clothing is not his own. That's That's strange. He wants to be out for his birthday, which means he
All right,
must have just
so
been brought in.
what is happening on this case? It's the final discovery date.
Yes, the state just gave us, uploaded some mental health records for the complaining witness and also some notes that were taken during their.
All right, who's the prosecutor on Alexander Rodriguez?
I have to.
His shirt says "Have a magical day." He's got shrooms on it.
They are going to upload, have not uploaded at this point.
He's got magic mushrooms on his
Thursday,
shirt.
my advocate Marina was out on Friday. She's currently meeting with the victim right now, but we do hope to get those notes done by either today or latest tomorrow morning. As a practice, I like to give the defense counsel the notes of the interview so they have everything. I did provide Marissa on Thursday or Friday the Brady stuff, but I do want to still give them the notes. As for the records, the complainant did go to counseling. We did rush those records. We already received those records and uploaded them last week as well.
All right, and so there's no more outstanding discovery.
From my everything, that's why we met with the complainant. We talked about the details. Any news information I already have requested, so I don't expect there to be anything else.
All right, January 14th is your last discovery date. I will not have another discovery hearing on this case. And on that date, state you need to be prepared to make an offer.
Yes, Judge, although I think we already extended
says-
an offer, but I don't anticipate.
I think it says "Have a magical day."
I think you rejected the offer, right?
It is my understanding my client is wanting trial.
All right, so it's going to be a quick turnaround for jury trial, but on that day, state if you are not planning on making a new offer, is that correct?
No, not from what we've already offered. And like I said, we will be getting those notes this week. I will make sure that happens.
All right, then on January 14th, if you have all of the discovery before then, which I'm being told it's just interview notes, then January 14th will be final discovery and plea deadline. The only way I'll change the plea deadline date is there some different discovery that suddenly pops up.
Right.
All right.
Thank you.
Thank you.
Yeah, she noticed the shirt.
Millard Cummings. Sure.
He sounds near
All right, was an offer tender?
Today, for the first time, Your Honor, we got an offer. My client would like some more time. I'd like one more setting to try to contemplate that offer.
All right, your plea deadline date is going to be January 9th. All right.
Thank you, Your Honor. Is that all we need?
You need to get a reset form. All right, thank you. Joe Manuel Hernandez.
Cindy, welcome.
Hello.
Judge, how are you?
All right, how are you doing?
Christmas Day.
Merry Christmas. Happy New Year. Happy Festivus. Happy Kwanzaa. Hi. All right. State, this is Criminal Trial Division.
Mr. Garrett.
All right. So are we complete with discovery?
Well, Judge, I don't know, well, I do know for the evading we are, but it's associated with DWI that the blood has not been come back. Yeah, that's a misdemeanor.
All right. And the misdemeanor,
It's a DWI blood
is it
discovery.
related to this case?
Yes, it was same.
It's the same incident, Your Honor.
Okay.
She skipped on.
All right. We'll come back on January 30th.
Boxing Day was completely ignored as
All
well.
right. Once you sign the reset form, you're excused.
Thank you, Judge.
Festivus is a
Shelby Rodriguez.
fictional holiday made up on the Seinfeld show,
Who's the attorney for Shelby Rodriguez?
which has become a real holiday, which is a weird thing.
All right. Just wait for your attorney.
Like people celebrate it.
Seth McDonald.
Your Honor.
Yes.
And also, if I could do 2 for 1, Joanne de Hoyos had Roberto Campos with the dismissal. It's the only case he had on the docket today.
All right. Could I see the file on Roberto Campos, please?
I can bring Seth McDonald up.
Yes.
Yes. Seth, come on up. Thank you, Judge.
You're welcome.
And Mr. Campos was here. He's in the back gallery, just standing there. You can have a seat. Okay. Yeah.
Good morning, Judge.
Good morning.
Misconduct. Thank you very much. We collaborated on the
All
topic.
right.
He asked me
If
what I
could give you an
wanted to
update.
talk about, and I
Yes.
suggested
know
this
this is set
case,
for
and he said it would be a good one.
However, on December 5th, I approached and you signed an order to appoint an investigator. You already signed it. And the investigator needed to have it signed by him. I already had Seth sign it, initial it. The investigator's in the hallway. I'm gonna hand this to the investigator and we should get the medical records soon. I hope so, very soon. Seth doesn't want to be here till, February. So whatever day we can come back for sentencing. I already checked with the state. They're okay with us trying to get the medical records.
All right, I'll recall it for January 16th.
Okay, January 16th. Thank you, Judge. I appreciate
Thank
that.
you. You're welcome.
Yes, Festivus involves a poll, an airing of grievances, and celebrate feats of strength. It's a wonderful holiday. A Festivus for the rest of us. The airing of grievances is my favorite part. Sometimes it's just good to get something off your chest, It's like I've been holding this in, but now that it's Festivus, we're going to let this out. Poll stream, you say? No, that was different. It was different. Someone's going in and out my front door.
No, that was
making a lot of noise.
Your Honor, may I approach?
Yes.
Yes.
Ivan, I think I would be down for that. What? I have to check my calendar. Hang on. Hey Siri, what day is Festivus?
Festivus is on Monday, December 23rd, 2024.
There you go.
Next week.
You're welcome.
Do you want to do a Festivus stream? We'll do a StreamYard. Everyone can come on. I don't have a poll. Well, I'll see if I can get a poll.
Okay, thanks so much. I can.
Does Amazon sell Festivus polls?
Oh.
Bless you.
No. Thank you. Would you please give Arlene Gay for copy?
Let's see. They sell Festivus sweaters. There it is. 8-foot aluminum residential indoor flagpole versus pole. Festivus pole. It's just a Festivus pole. It's just a regular pole. Should it have gold fringe? Should there be like gold fringe somewhere? Should have asked for a portion of one of the utility poles that got damaged in front of your house this year. Appropriate grievance pole. That pole was my grievance is the problem. I'm not sure if the pole can serve double duty. In college, we just used a closet rod. Yeah, Festivus, no politics in your grievances. We can't have any political grievances. This is a Pickles, not politics. Maybe I'll just set the camera out there and live stream the poll. I do have some lights. I've got a strand of lights right here. Do you think I'll get in trouble for decorating the poll that I don't own? Let's see. Do they work? Yes, these ones work. I can put these on. This is 16 feet of lights. I can decorate the pole.
Okay.
can't find a good Festivus poll. I think size matters on Festivus poll. I know they have mini ones, but I don't think that would be good. Oh, I could get a Festivus candle. Check mod chat. I'll take a peek. Hang on. A Festivus candle. This is. Hang on. Let me put a link for this in chat really quickly. Hold a second. Okay, you get a link for this one. Copy. Go to my stream. Okay, live chat. Okay, I just put a affiliate link for a Festivus candle, and the description on this thing is the best. Smells like disappointment infused with grievances. It smells like disappointment. So you're like, oh, it's always a letdown. Oh my goodness. I might have to go back.
I had to step out to CPS.
I might have to go back and watch the Festivus episode. We are still in verdict watch right now with Judge Boyd. That's why we're hanging out here, waiting to see if the jury comes back with a verdict or with a question. There was a case we just heard. We picked it up at the closing statements. It's a BB gun shooting case where the defendant is charged with assault with a deadly weapon. It's literally the Christmas story in court.
The other one we just had.
Was an eye loss? No. As a matter of fact, nobody was even hit. They were in the pool and heard splashing and said that they heard like basically the BBs slamming the water and splashing water all over the place. Anyone who shot a BB gun into water, as I have many, many times, knows that's not how it works.
Thank you. Okay, all right, thank you.
Yes, Shark.
Luis Mora?
We obviously need to do this in a respectful way, but the open to the airing of grievances against me or others, I think would be appropriate. Invite Runkle to co-host it. I'm sure he can find some grievances.
I'll be right back. I apologize. I was
No problem. I'll call it after this one.
Thank you.
I have a grievance.
Good morning. All right, court is calling 2022 CR 2485, State of Texas versus Luis Mora. Could I have parties announced for the record for the state?
I can't get Ian Runkle his package.
Jay Moritz, Your Honor.
And are you Luis Mora?
Sure.
Are parties ready to proceed on the motion to revoke?
We are, Your Honor.
Yes, Judge.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Sir.
And did you understand it?
Sir.
Are you the same Luis Joaquin Mora who was placed on deferred adjudication in 2022 CR 2485 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on April 14, 2022 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4, in Banter County, Texas, the defendant Luis Joaquin Mora, the defendant failed to report to the supervision officer as directed for the months of January, February, and March 2024 in violation of condition number 4.
How do you plead to that? True or not true?
That is true.
I have
Yes,
my
ma'am.
Festivus poll.
Your Honor, move to waive.
Any objections?
No objections, Your Honor.
With the
Did
base.
you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I understand. Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. The court doesn't have a trial court certification.
Okay, they're withdrawing the motion. You're gonna go adjudicate?
so it's pleasure. Sorry, just a huge. Oh, I'm sorry, Judge.
No problem.
By the way, congratulations on your YouTube channel.
I'm sorry, what?
Congratulations on your YouTube channel.
Thank you.
Oh, don't play favors with the court,
No,
okay?
I'm not there.
So here's the thing, and this is just for me to make sure that the legal system is transparent. The legal system should be transparent. Everybody should know what's going on
Yes, ma'am.
with the court system.
Yes, ma'am.
And this channel is through the government, through the state of Texas. It's not my channel.
No, okay, I understand.
All right.
I understand it.
She does not make money off this channel.
All right.
This is a revocation of your probation, okay? And if the judge revokes you, you do have a limited right to appeal.
Yes, sir.
Does the poll have to be bigger? Okay.
All right.
Here's my question. Is the poll
So is there
size
proposed agreement?
There is, Your Honor.
congruent
Yes. It is to deny the motion.
with the
and
grievance
continue on
size,
the
or
first,
does it need to be?
Extend the individual for 18 months, and then for DDRF, and then state ISF, and substance abuse track, should he not meet the criteria for DDRF.
All right, so why is he not reporting? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, lower your hand. Why are you not reporting?
I had gotten a hypertension pulmonary lung disorder, and they kept me in the hospital for a month because I was going through a divorce. So then after I got out of the hospital, I got scared.
So when were you in the hospital?
If I'm correct, it was January. No, right after I was done reporting.
This
had to be June, if I'm correct. January, June, one of those.
So June.
I think it was June. Yes, ma'am.
All right, so you were in the hospital
For a whole month.
for a month, the month of June.
Yes, ma'am. And then they wouldn't let me out. And then when I got out, I was so scared.
When did they release you?
It had to be around July.
All right, so you were released in
20
July.
Like July 29th, if not almost the 30th.
All right, and so nobody's seen you since July.
No, ma'am. And I had gotten scared. That I'm not gonna lie. So I didn't report.
All right, this doesn't make sense to me that he's not reporting since July and he has a reason that he was in the hospital.
I understand, Judge.
So does anybody have proof that he was in the hospital?
Paperwork, but it's not with me. Of course, it's I have it in my file. Works at the house.
Well,
That's
came
not going to
from-
help
from the
today.
jail. No, that's fine.
No. Who else lives at your home with you?
Well, I'm to be honest, I don't have a home. I just have my paperwork with a friend of mine,
Oh, who's the paperwork with?
Jessica.
Jessica who?
Jessica Ambrodos.
Right. You have her number?
No, ma'am, I don't.
Then how do you get in contact with her?
I was staying there for the moment. They're just like.
Oh, do you know the number to that household?
No, ma'am, she doesn't have a landline.
All right. So here's the thing. If he is saying that he was in the hospital, which I don't know if it's true or not, I need proof of that.
I have paperwork.
What he's pleading true to is not reporting January, February, and March of 2024.
All right. So
He's talking about being in the hospital in June, and he quit reporting because he got scared after that.
Yes, ma'am.
is probation here?
Yes, sir.
Yes. Any objection to the court review and the court summary?
Not from the state, Your Honor.
No, Judge.
All right. Could I see the court summary, please?
And we're showing his last report date was December of 2023.
Oh.
So I'm not sure if he's referring to June of 2023.
That is all. Yes.
And probation, why are you requesting DDRF?
For his substance abuse issue, and I'm not sure if he just completed, I think he completed a TAP evaluation in December of 2023, and they were recommending
based upon the UAs and stuff, Judge, he does have an issue with the controlled substance.
All right, I don't understand. I'm not going to continue. I don't think you're a good candidate for probation. In this court, I always tell people if they need help, let us know. You've been on probation
Sorry, I'm
since
decorating my Festivus pole right now.
2022. And for that time, you've been missing for well over a year. So the court is going to grant the motion, find you guilty. Would you all like to speak to punishment?
See the.
Probation, did he pay the $60 restitution for laboratory testing?
It's coming along nicely.
No, Your Honor. He's paid a total of $56.
All right, I am going to order the $60 restitution for laboratory testing. I'll order the therapeutic community. It doesn't increase the time that you're that you're in custody for this sentence. It will just be able to help you with any drug issues you may have. And it appears that you have drug and alcohol issues based upon the court summary. So have you all been able to discuss a time?
No, I've not discussed that with the state has a recommendation.
All right, state, what is your recommendation?
It's the $3,000 like 5 years.
All right. Defense?
Judge, it's a deferred case. On the criminal history, I didn't see anything. I don't see why. Well, first of all, all the reasons have been, there hasn't been any crimes while he's been out. He hasn't committed anything other than testing positive for the drugs that he's taken for the mental issues that he's got. And that's why he was with the dual diagnosis program to begin with. So I'm looking for the minimum of 2, Judge. If you are still going to sentence to prison, I would like to get him a treatment program to get him into something. But I don't think it fits the needs to sentence him to 5 years.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it?
No, ma'am, I don't think I have. I don't think.
Well, so this is what has happened. So I've revoked you. And what that means is because there was not an agreement on punishment, then you do have a right to appeal. That right to appeal is limited though. It's limited to whatever the allegations were in the motion that you pled true to.
Yes, ma'am.
You cannot appeal and say, I'm appealing because I was on deferred adjudication and I shouldn't have been on deferred adjudication.
Yes, ma'am.
That ship has sailed. So you do have a right to appeal, but it's a limited right to appeal. Do you understand?
I don't understand that. May you please explain that to me?
All righty. So anyway, did you sign that document entitled Trial Court Certification of Defendants' Rights to Appeal? Is your signature on that?
Yes, ma'am.
All right. Because this was not a plea bargain agreement, you do have a limited right to appeal. Your attorney will explain that to you. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right. So we're off the record. I'm requesting the therapeutic community for you. It does not increase the time that you're in custody, but it may help with any issues you may have.
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you, ma'am.
You're welcome.
Appreciate it.
Yeah. Pretending you don't understand is not going to fly with this judge. Okay. I'm pretty happy with the Festivus decoration. It's turning out quite nicely. Although it hurts my hands. Ow. How long she sentenced him? 3 years. He got 3 years with credit for any time served. Yeah, you don't just not
All right,
report for a
Amy,
year.
who do you have again, please? Okay.
probably could have hooked this.
All right, Shelby Rodriguez.
Probably just should have hooked
All right,
this up
so
to
today
a-
an offer is due.
Oh, they match. Necklaces and black shirts.
All right.
Could have just hooked this up.
All
to a
right, I'm going
power
to set
drill.
this for a plea deadline date. And I'll set it for January 14th.
Yes, that's perfect, Judge.
All right, thank you. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you,
I
Judge.
followed
Thank you.
my lawyer's lead. He said, wear something black and frilly.
Cody Salazar. Who's here on Cody Salazar?
Oh.
All right, just one second. We'll call you back, don't worry. Jose Lopez? Yes.
Jose Lopez. That was
He's in custody?
He's in custody.
Yes.
All right. Come up here?
Yes.
Okay. Jose, let's go.
Excuse me, person in the dress, the flowered dress, you're not allowed to talk to inmates. If you do, you will be sent from this courtroom.
Good morning, Judge.
Good morning.
How
How are you feeling?
I am doing better.
Oh, that's good.
Yes, my wife took good care of me.
Oh, okay. All right, so what we need is a jury trial date.
Yes, sir. Yes, ma'am, at this time.
All right, how long do y'all expect this jury trial to last?
Oh, ag robbery, what, 3-4 days maybe?
All right, so which
4
case are you all
days?
proceeding on first? You got the aggravated robbery, retaliation, and injury to the elderly.
Whoa.
Maybe.
Some pretty hefty charges.
Okay. All right. So if y'all will confirm with Ms. Ferguson on a jury trial date.
All right, thank you, Judge.
All right, thank you. And then once you know the date, let me know.
All right. Still talking. Oh, okay.
March 4th? All right.
There was an incident with him at the court date a while ago.
Mhm.
He wants to apologize for his conduct. He had a bad day.
All right, no problem. Let me just tell you, I scrubbed my brain of that. So it's like it never happened.
I understand that, but just in my mind, I'm a adult, you know, and I shouldn't have had that, like, outburst or nothing like that, you know, like that's uncivilized, you know.
Mhm.
So like,
All right, well, I
I
appreciate.
don't matter what I'm facing, but still, like, I wake up. That's all right.
Well, I appreciate
Thank
your
you.
apology. You're welcome.
Apology accepted. Now, got another issue. Okay, look at my pole. I decorated. It has lights. It's a Festivus pole. It's all decorated. Look at that. Beautiful. Okay, we're ready for grievances.
Oh, yeah.
I gave him the link.
Sure. Oh. Thank you.
It's everything's fine and dandy until I tell you that this Festivus pole happens to also be the base for Mr. Bones here, which
Oh, all
now
right.
suddenly the pole.
All right, I'll get to you. What's your
going where it does.
All right. No
Looks
problem.
different. Yeah. So there we go. It's ready though. All right. Welcome to the Lawyer You Know friends who are here. Appreciate you guys joining. It was a privilege to be on with Peter. He's one of the great pillars of LawTube. I've been doing YouTube right for a long time, and it was a privilege to be on with him. It was wonderful. It was just a blast. I loved every minute of it. There goes monetization. Yep. So, Sinbad, I'm gonna use that for the poll. I think we're gonna do an airing of grievances next week. So if you have complaints, save them till then.
Yeah, I am concerned about you and your cough. I'm gonna walk you to the doctor if I have to. Okay.
Oh, I'm sure this gripe will come up. We are sitting with this judge because we are in verdict watch right now in her court. We jumped in on a trial. Christopher Morrison's been charged with aggravated assault with a deadly weapon. The facts of the case: he shot a BB gun at a pool. People were swimming in the pool. Not just people. A dad and his 3-year-old son were in the pool. The dad happened to be a police officer. There are also allegations that he shot the window across from his balcony, his apartment balcony, and there is a broken window entered as evidence as well. The BB gun could fire around 330, 350 feet per second.
Cody Salazar.
The charges are the same as if he used a 9mm or a deer hunting rifle to do the same thing.
All right. State, were you able to tender an offer today?
We have not yet. We did talk about possibly an offer, but I haven't officially extended an offer. I think the French wanted some sanitary information he has that I don't take.
Good morning, Judge.
Good morning.
Last time we were here for discovery, there were some notes that I was able to review from the state today. I'd like some time to absorb them. I also received some documents in my office Friday, which I have not had the chance to look over, and I would appreciate a little bit of time to do that. So I would respectfully request one additional discovery setting, and then we can take this from there.
And I think based on what he finds, and if he shares with me, that may also affect my offer. So that's why it's not official.
All right. January 30th is the last day. An offer will be due. And then after that, if an offer is not tendered, be moving into jury trial without one.
Thank you, Judge.
All right.
Appreciate you.
You're welcome. Thank you. Have a good one.
Thank you.
Have a seat over there.
Apparently, I can order the Festivus candle in different scents. Like I can get apples and maple bourbon in a Festivus candle. There's also one called Bite Me. That's the flavor.
No, Discovery.
It says black cherry soda in parentheses. But it's been made with genuine feats of strength. Looks official. Ooh, fresh linen candle. Smells like laundry. I'll pass on that one. I think the apples and maple bourbon in honor of the favorite, my favorite, maple bourbon pickles, spicy maple bourbon pickles. Let's see if those will be a good Festivus candle. Make sure it gets here on time. Yes. Front door.
Zion Taylor.
Morning.
Good morning.
Oh, Amber, I'm going to make you
All right,
telework
what's
that
happening?
day.
Morning. Johnny, last time we were here, we had indicated to the court that we thought there was some discovery that was pertinent to the case that that the court allowed us to have an investigator.
Yes.
That he had uncovered. I've heard back from that investigator last week. He told me that he told me as to the progress of his actions. He did find a report. It's not, it wouldn't be something that would be flagged on this particular case through the DA's office, but we do believe that it's pertinent. He is in the process of subpoenaing the the videos. They they responded to us with a report, but not with the videos. So we should have that subpoena ready by the end of the day or tomorrow at the latest.
Is that a backpack on that
All
other
right,
attorney?
recall this for January 30th for discovery.
Thank you, Dave.
All right, once you sign the reset form, you're excused.
Thank you, Dave.
You're welcome.
Suit coat with the backpack. It doesn't look comfortable. Suit coats aren't comfortable for me anyway. I wear them when I have to.
Yes. How's it going?
It's going. CT
How's the
intakes.
leg and everything?
It's going better. I have 2 more months before I have my year checkup. Oh, sorry. If that goes well, then I get the screws removed.
Okay.
So
All right.
slowly but surely progress.
All right. Have a good one.
I didn't have a suit for a long time. I wore one for a long time, then I didn't have one for a long time, and then I was asked to be security for events around the Olympics. And they said you have to wear a suit because we were sort of like undercover security. And so I bought a suit for that. So I've worn a suit for a couple security gigs, which were a lot of fun. But I don't like wearing a suit just regularly, especially in North Carolina. It's too hot to wear a suit almost always. This is my Olympic suit. Not armed security. I would need a license for that.
No, I'll double check. Just give me a second.
But just private security or any metal detectors, bag searches, things like that. Found a few guns. I didn't think my gun would set off the metal detector. Really? It did. And we found it. Hoping to get an answer here from the jury, but I'm not. Not seeing it. It is time for lunch. Well, what I'm going to do is I'm going to keep, we'll keep Judge Boyd on record, and then if anything happens on lunch and you guys see it, let me know. We'll come back immediately. Did I wear dark sunglasses too? I don't think they were dark. It was sunny outside. Mostly it was just carry a radio, little piece of, the ear fungus in the ear so we could hear what was going on without everyone else hearing what we were talking about. We had to tail some people that were problem makers, but we'd allow to be there until they caused a problem. It was fun stuff. A couple medical issues. Muzzle shirts. No, nothing so exciting. Did I talk into my wrist? No, I had it just inside my my suit coat, so I could just the button and the mic was just inside, so I could just move my suit and talk without having to be like, this is Eagle 7. I've got eyes on the subject. No, it was pretty lame. I didn't talk much. It's a good day when you don't have to talk on the radio at all. Hands crossed behind your back? No, because that puts me at a severe disadvantage. Hands at the side. Hands at the side. Not in pockets and not crossed. Do you have a button, Cam? I have a bug, if you know what a bug is, but it's a microphone only, no video. I built it myself. I don't think it's legal for me to turn on in the United States, but I didn't build it in the United States. I built it in England. Don't think it's legal there either. Hey, Mrs. R.A., how are you doing?
Good. How are you?
Great. Do you want to do lunch? I don't know. Panda Express.
No.
I figure we'll start with that and then we can negotiate. What's your offer?
Salad.
Salad. So what's halfway between salad and panda? Is that Wendy's?
That's like sandwich.
Sandwich. You could do a sandwich. Pizza. Pizza. All right. The judge is at a lull in the video here, so here's what we're going to do. I'm going to keep the recording going, so we're not going to miss anything that happens in her court in case that verdict comes in, because I do want to know how that BB gun case ends up. But we're going to take a break for lunch. We'll take about an hour, unless, you know, the verdict comes back, and I might have to jump back in a little earlier. I'm pretty much not getting Panda. I think that's what you said. Not getting Panda Express. So is RA is the real M? Halfway between Panda and salad is Taco Bell. I think even on the map, I think you're right. I think you're right. It's halfway to Taco Bell, or halfway to Panda. So here's what we are. We're looking at picking up a new case here in the short term. Monday next week, we're going to have a Festivus airing of grievances. I have a poll. Oh, you've got to see. Sorry, you've got to see the poll I have for Festivus. It's a good one. All right. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe to go live again. Thank you, all the new people who joined us over who came from Peter, the Lawyer You Know's channel. Thank you very much. It was a privilege to be over there. Peter's amazing. I don't have to say that. You already follow him, but if you don't for some reason, you should. He's a very insightful lawyer. I love his delivery style, the way he answers questions, and explains it in the way that even I understand. it's great. All right. I think that's it. I'm going to have lunch. I'm still pushing for Panda. I'm not winning, guys. I'm not winning. We'll see you guys after lunch. Have a good one.